I directed the finance department to file the affidavit on the last date. Lordship, I'm seeking 3 weeks of accommodation. I've informed the petitioner.
Why?
Lordship, where some time was required by the department to file the affidavit. Lordship.
You have not filed.
No, Lordship.
Once I have already imposed 10,000.
Lordship, one last opportunity. Lordship, I directed on the last date.
Another 10,000.
Lordship.
1,000. Is that your case? Where you appeared?
No, no, Lordship.
10,000 has been imposed upon you, no?
That is different.
It's another case.
Lordship.
So here we impose 10,000.
Lordship, one last offer. I'm just asking for one opportunity. Lordship, I directed on the last date. Time was given, Lordship. I had received the copy also from my level friend, Lordship. One opportunity, Lordship. Lordship may impose any cost of the fee, Lordship.
Okay, let us see when the matter reaches whether an affidavit is required or not.
Lordship, my affidavit will be required, Lordship.
I don't know. Well, it is for the court to decide. Otherwise, we may also apply the doctrine of non-traverse. Wait.
Above the list, item 1.
The order of the Honorable High Court, we have filed additional affidavit without annexing the policy copy.
The vehicle belongs to it, so he becomes a first party.
First part, and he stepped into the shoes of the owner. And better than ask for the day, the conducting council is.
The partner matter. Question does not arise. You've got a stake. You have made any payment?
Complete stay was given as the insurance company is not liable in that case because the system.
You got a stay. You have got a stay. Full stay. You have it after 5 years. I impose a cost upon you. The claimant. The partner matter. Cost starts from 50,000. How much? 50,000 on the lawyer. I could see a recent judgment of the Supreme Court on also on this point.
Persons to the judgment of Nigam and Nigam.
Yes, and the recent judgment has been delivered, I think, by Sanjay Karol, Justice Sanjay Karol. You have it? A very recent judgment on this point only. That he steps into the shoes of the owner.
And as per policy condition, personal accident coverage was taken, and as per policy, the claimant was entitled to 2 lakh only.
Only 2 lakhs. But have you paid that 2 lakhs? Why? Why?
Our contention herein is that
I understood, but he is otherwise entitled to 2 lakhs. In their personal accident fee. Then why haven't you paid the 2 lakhs? And having not paid the 2 lakhs from 2013, we put it at the interest of rupees 6%. Then obviously the amount goes much higher than 3,94,000. 10 years have gone back. Hello, we impose the cost of 50,000. The partner matter, nothing. Hello, we dispose of. We have the judgment, we dispose it of. The partner matter, we have already heard.
Paragraph 22 of Nigam judgment, where it is stated that the insurance company is not liable.
So it will be 2 lakhs plus interest on the date of filing of the claim petition. Reason if we heard Ms. S. Roy, the limit counsel appearing on behalf of the petitioner. Appellant.
Right.
So appears on behalf of the respondent number. Appears on behalf of the respondents. Is an appeal under section 173 of the Motor Vehicles Act 1988. Challenging the judgment and award dated 10/6/2013, passed in MAC case number 231 of 2009, whereby the learned member Motor Accidents Claims Tribunal Vishwanath Saryalis Punitpur had awarded an amount of rupees 3,94,000 along with interest at a rate of 6% from the date of filing of the claim petition. The ground of objection taken, because the ground of objection taken in the instant memo of appeal is that the present case falls within the ambit of section 163A of the Motor Vehicles Act 1988. And as such, the learned tribunal was not justified in awarding compensation, stating it to be similar to a proceedings under section 166 of the Act of 1988. Ms. S. Roy, the learned counsel appearing on behalf of the appellant insurance company, submitted that the deceased was the son of the owner of the vehicle. And as such, the the
Who was driving the vehicle?
the deceased was the son of the owner of the vehicle. And as such, the deceased had stepped into the shoes of the owner at the time of the accident. And as such, the compensation which could have been payable at best would have been in terms with the contract of insurance entered into by the appellant insurance company with the owner of the vehicle. This court have duly perused the materials on record. Take in the backdrop of the above, let this court now take up the facts which led to the filing of the instant proceedings. a vehicle bearing Maruti car. Next, a Maruti car bearing registration number AS12F4096 was owned by one Sri Santosh Upadhyay. The said vehicle was insured with the appellant insurance company. On 14/4/2009, when the son of the owner, one Rajiv Upadhyay, bracket since deceased, was driving the said vehicle, he met with an accident and unfortunately met with an accident and unfortunately he expired. It is under such circumstances a claim proceedings was filed under section 163A of the Motor Vehicles Act 1988. The appellant insurance company appeared and filed a written statement and took the plea and took amongst others the plea that the offending vehicle was not driven properly and there was a breach of section 1649 of the Act of 1988. And as such, the appellant insurance company was not liable for payment of compensation. So, the learned tribunal, on the basis of the pleadings, framed three issues which are mentioned herein under page 44. First, the learned tribunal by the impugned judgment and awarded an amount of rupees 3,94,000 along with interest at the rate of 6% per annum. In doing so, the learned tribunal, however, did not take into account that the proceedings so filed were the proceedings under section 163A of the Act of 1988. But the learned tribunal dealt with the said proceedings as if it was the proceedings under section 166 of the Act of 1988. This court, having perused the materials on record, Where's the insurance policy?
Additional affidavit. That page.
Including the additional affidavit filed before this court.
Limits of liability clause.
Wherein at Annexure B, the insurance policy have been enclosed. From a perusal of the said insurance policy, it is seen where the it is seen that there was a personal cover taken under section 3 for owner driver to be rupees 2 lakhs. Pusto. In the backdrop of the above, let this court now consider the prevalent law in this regard. Pusto. The Supreme Court in the case of Oriental Insurance Company Limited versus Rajni Devi and others reported in 2008 5 SEC 736 had duly dealt with the provisions of Section 163A of the Act of 1988 and observed that the liability under Section 163A of the Act is on the owner of the vehicle as a person cannot be both a claimant as well as the recipient. The heirs of the owner could not have maintained a claim in terms with Section 163A. For that purpose only, the terms of the contract of insurance could have been taken recourse to. This court finds it relevant in this regard to take the note of paragraph number 7 of the said judgment, which is reproduced herein under. From a perusal of the said paragraph, it is seen that in the case, it is seen that in a case where the third party is involved, the liability of the insurance company would be unlimited. However, in the case of compensation, when compensation is claimed for the death of the owner or another passenger of the vehicle, the contract of insurance being governed by the contract qua contract, the claim of the insurance company would depend upon the terms thereof. Taking into account the above proposition of law, it is the opinion of this court that the petitioners here, the claimants herein could not have maintained a proceedings under Section 163A of the Act of 1988, and the petitioners herein, that the appellant, the claimants would have been only entitled to the amount which was taken as a personal cover, which is rupees 2 lakhs. Under such circumstances, the impugned judgment and award by which an amount of rupees 3,94,000 was awarded in favor of the claimants, along with interest at the rate of 6%, is required to be interfered with. Next. This court also cannot be unmindful of the fact that there was a contract of insurance entered into by and between the owner and the appellant insurance company, whereby the appellant insurance company was contractually obligated to pay an amount of rupees 2 lakhs to the owner of the vehicle on account of the accident. Accordingly, this court therefore modifies the impugned judgment and award thereby observing and directing the appellant insurance company to pay an amount of rupees 2 lakhs along with interest at the rate of 6% from the date of filing of the claim proceedings within a period of 6 weeks from the date of the instant judgment. The said amount be deposited before the Motor Accidents Claims Tribunal, Biswanath Sareli, within the time stated herein above. within the period stated herein above. Next. The Motor Accidents Claims Tribunal, upon receipt of the said amount and upon an application being filed by the claimant providing due bank details, transfer the said amount to the bank account of the claimant after proper verification. Above the appeal stands disposed, so and so finished.
For admission, item 2.
Yes, anything happened? Done.
It is done. The finance has given the concurrence and accordingly, one of the judicial has issued the letter. Now the benefit will be given. Now the pensionary benefit for that period, that has been already, concurrence has been given by the finance and the benefit will be now given to the pension. Kindly see the letter, the judicial has already written to the AG and the second page, my lord.
So now it has been done.
Down.
Now when is he getting?
Kindly see serial number 4, second page, serial number 4. The CDM, the Civil Judge Junior Division, North Salmara, Bhayapuri, has been requested to process the pensionary benefit.
Done.
From there, we will be processed.
So it to him, he should also be satisfied. See? 2019 matter is finished. You should be now happy.
Time may be my friend. Area, that is 27 lakhs. Pension will be continued, that will be finalized.
Huh?
And the other amount, within a specific time they will get. Our provisional pension will be finalized. And the other amount, that is tax ratio,
Why should I say all these things? If you don't get it, then you come.
now only I am getting the provisional pension.
Now you get the full pension, everything will be done.
Pension will be finalized. The other benefit,
How do we know that, how do we suppose that they are not going to give it?
It is already quantified. It is already quantified and it is placed before the lordship.
And it is being sent to the accountant general.
Yes.
So the accountant general will take it. Who is the accountant general? Yeah, he will take it from there. Show it to him. Give it,
I have seen.
give it to him. They have only, we have to think about the government of Assam. It is not the finance department. He can have the luxury of having 5 photocopies. Government of Assam does not have.
Finance department instruction with the second page, might not will see the endorsement.
Thus, the creation of the Iman in the Iman for payment of pension is subject to the condition that RIA will determine the A. Ensure that there is a budgeting provision. What is this? Will determine the concerned HA head assistant. What is HA?
My lord, house rent allowance, house rent allowance.
That is HRA. What is HA?
Have to-
HA is head of account. Goodness.
So
For
far,
payment of pensionary benefits subject to the condition that final will determine the concerned area. Head of account and ensure that there is a budgetary provision. So what is this? Putting a hook out there?
madam, this is the binding, madam, we may bind our person. Tomorrow it will happen that, madam, whenever a board is created, he gets the pension, then again it gets locked up. He may not expenditure control to him.
Chalo.
They are duty bound. Permit him not creation of supernumerary board. That did happen.
Heard Mr. AI within the learned counsel appearing on behalf of the petitioner. Mr. D. Nath, the learned senior government advocate, appears on behalf of the Judicial Department of the Government of Assam. Mr. R. Bapuzari appears on behalf of the Finance Department of the Government of Assam. And Mr. B. Chakraborty appears on behalf of the Accountant General at AE Assam. And Mr. Kedas appears on the Guwahati High Court. Do you get separate fees for everybody? The present petition was filed by the petitioner, being aggrieved by the communication dated 26/8/2019 issued by the Office of the District and Session Judge Bongaigaon and the board's resolution dated 16/8/2019, whereby the prayer for payment of area salary and finalization and disbursement of pension of the petitioner was rejected. The petitioner also, by way of the instant writ petition, sought for a direction upon the respondent authorities and more particularly the district and session judge Bongaigaon to finalize and disburse the pension of the petitioner with all consequential retirement benefits and make payment of 1 month area salary of the petitioner and also make payment of the salary of the petitioner from 1/8/2017 to 7/12/2018, which period the petitioner rendered service in excess from the original date of retirement of 31/7/2017. You can't get that.
That is my prayer, but from the time of my retirement,
So what? You can't get that. Why did you work?
excess period, I am not excess period, there I am the work I am excess period, that is I am.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner at the outset submitted that the petitioner would not insist upon the salary for the period from 1/8/2017 to 7/12/2018, taking into account that the said period was beyond the period of retirement. Beyond the period of retirement, which is 31/7/2017. In the backdrop of the above, in the above backdrop, therefore, the question which arises as to whether the petitioner herein would be entitled to the other reliefs which have been sought for. What is your name? Ajal Chakraborty.
Anwar,
No. This court have duly heard the learned counsels appearing on behalf of the parties and have also taken note of the order stated 27/1/2025 and 24/2/2025 passed by this court. The hitch for which the petitioner was not getting his salary. You were getting your salary, earlier salary,
For 4 months of my retirement, it
was not getting his dues, was on account of the fact that the petitioner's post was not a regular post.
not confirmed. Post was regularized, but not, service was not confirmed. That was their concern.
What?
But you will find the repeating it is there. Service was
You were temporarily appointed.
initially temporarily happened,
You-
subsequently regularized.
You were regularized.
Yes, but my salary was stopped because of the fact that it was not confirmed. Perhaps it was not confirmed. Your lordship will find this letter.
No, then why was there necessity for creation of a supernumerary post?
That was my lord, they said that your lordship will find.
Obviously, your post was not a year. There
Page
was no, nothing out
Page
there.
31 of my petition, my writ petition.
I still remember telling you that if I was the judge who was doing that, initially taking it up, you would not have got a single penny. Didn't I say? Didn't I say about that judgment of, what is that judgment again? I forget that.
Page 31, my lord, my candidate. That was
Ah.
it.
Reply so and so, office of the Munshi. So far as the
From my lord,
status is not
What
yet permanent and you are not yet confirmed as such, I cannot sign.
I have highlighted the word perhaps.
By giving you the thing. No, but the copy of the list of the money. You were holding to a sanction post, but you were not regularized.
They say this is because of using the word perhaps.
No, forget about that. Where is your regularization order? Because a regularization order has to be on in respect to a post.
Page 27. Sanction post here. Page 27.
No, this is creation of a post. Where is your order of regularization? No, that is why it was not done.
That madam, that so it has been put to tenant, lordship will find at page 46, 47. That makes everything clear, man. Page 46, 47. The last two pages of the report.
That is why to be holding a non-retention post for which his salary was stopped. The post against which Sri Hussain was drawing salary was already filled up in Gwalpara district, which is evident from so and so, and wherein it was mentioned that from Iman onwards, the 3 posts of copies against the sanction number remained filled up. Further, he superannuated as such unwarranted for release of 1 month's regular salary, and his release for the salary year cannot be allowed. You were not appointed to a, you were appointed, but there was no post. That is why there is a requirement of a supernumerary.
Madam, bifurcation of two districts, Gwalpara and Konak. Because of the bill.
Nothing happened. It is because of the orders passed by this court earlier. Anyways, let us not go deep into this aspect. Have they duly taken note of the orders passed by this court dated 27/1/2025 and 24/2/2025? Whereupon, from which it can be seen that pursuant to the undertaking given before this court by the Judicial Department of the Government of Assam, there was a move to create a supernumerary post so that the petitioner's salary, petitioner gets his dues, more particularly his pensionary as well as his retirement dues, and the period during which the petitioner worked is regularized. Full stop. In pursuance to the order dated 24/2/2025, the matter today, Mr. Dinath, the learned counsel appearing on behalf of the Judicial Department of the Government of Assam submitted that the Governor of Assam had conveyed the sanction for creation of a supernumerary post with effect from 23/11/1993 to 31/7/2017, personal to the petitioner in the office of the Munsif North Salmara, Abhayapuri. Now the office of the Civil Judge, Junior Division, North Salmara, Abhayapuri, under the establishment of the District and Session Judge, Bongaigaon, for payment of pensionary benefits. It is also seen from the said communication that the said sanction of creation of the supernumerary post is with the concurrence of the finance bracket E Roman 3 bracket close department and as per finance SIU department's communication dated 2/4/2025. Pusto. The relevant push the said communication so placed before this court during the course of the hearing is kept on record and marked with the letter. Except me, nobody does X, Y, Z. So let me look what have I done. Marked with the letter X. Full stop. The contents of the said communication being relevant is reproduced herein under a upar Government of Assam of a joint LRM. Mr. R. Borpujari, the learned counsel, appearing on behalf of the finance department, had further submitted that have further placed the communication issued by the finance SIU department dated 2/4/2025, as well as the note number 78 and along with the communication dated 2/4/2025. Mr. R. Bopujari further has drawn the attention of the court that this communication dated 2/4/2025 was issued pursuant to the note put up in the note sheet, which is note number 78 dated 2/4/2025 under the signature of the Undersecretary, Finance SIU Department.
So
Pushto.
it will be finance within bracket EC3 department.
Huh?
That is the annual.
Finance bracket EC Roman 3 Department.
But it's a control.
Pushto. The communication dated 2/4/2025 along with the note attached thereto, note number 78 attached thereto, are collectively kept on record and marked with the letter Y. Pusto. The contents of the said communication dated 2/7/2025 is reproduced herein under. A copy to him na lage, huh? Right. Pusto. Further to that, the note number 78 is also reproduced herein under. Pusto. From the above documents so placed, kept on record and marked with the letter X and Y, it would be seen that the petitioner's period of service with effect from 23/11/1993 to 31/7/2017 have been regularized by creation of a supernumerary post, and the petitioner would be deemed to be in service regularized by creation of a supernumerary post personal to him, and it would be deemed that the petitioner have been in service with effect from 23/11/1993 to 31/7/2017 as what post?
Copy.
As copyist, no? As copyist. Copyist. Post. Taking into account the above, it is the opinion of this court that the petitioner therefore would be entitled to all pension as well as all retirement benefits as is envisaged under the Assam, what is that code? I forgot the name.
Assam Services Pension Rules 1969.
1969. Accordingly, the instant petition therefore stands disposed of, thereby directing the respondent authorities and more particularly the respondent number whom respondent number 3, 5, 3 and 5. 3 and 5 because pension he is going to do and 5 is district and session judge is going to do. Huh?
R5 will be the review.
The respondent number 3 and 5 to take appropriate steps for finalization and disbursement of the pension of the petitioner regularly, along with the area pension, taking into account that the petitioner all along have now only received the provisional pension, and further other retirement benefits to which the petitioner is entitled to as per law. With the above, the instant proceeding stands disposed. Anything?
Kind of the word area, my lordship, maybe please to admissible, whatever is admissible to implement.
No, I said, I had made it very clear. Area salary I didn't say, the areas only on account of that he is receiving provisional pension. I said that. Be more, no?
The date of my creation of that book.
So, regular pension, no. His regular pension will be from 2017.
That's what, from 2000, the day when we superannuated.
So therefore, there will be some amount which will be payable because he is getting the provisional. Otherwise, how do you regularize the provisional?
But they came my lord, 2017, perhaps it will.
Huh?
Prior to 2017.
Prior to 2017, he is not getting anything. I'm not giving him anything. He's only from 31/1/2017. No, he's retired.
And I am getting provisional pension from November 22.
That will be adjusted.
So all these people. So don't worry. I'll move it.
But it also in question number 7.
Huh?
3, 4 and 7.
3, 4, and
3, 4, sorry.
I am on.
7 is who?
7 is the municipal. Because our data has instructed him to process it.
Public.
And then was the immediate employer, my lord.
Controlling authority.
3,
Yes, what is this? Item number 3.
In this case, the respondent number 5 is already filed an evidence in opposition. We are supposed to file a reply, lordship. the reply is ready. We are going to file it today itself, Lordship. So may I get the
Affidavit was filed in the year 2023.
Lordship, the file has been.
So if you have not filed it, why should I? You are only entitled to file within 7 days. Now tell me, what is the case, Mr. Monta? What is this case?
This case is that, my lord, there is a selection for post of LDA from gate post staff from peon and Charikaram. So that criteria is seniority come merit. So he says that I am the senior most, so merit is not required.
No.
That is the case. So we,
Don't spoil your time with that reply. Senior would not do. Yeah, seniority come merit means seniority will have importance.
Yes.
But there has to be a minimum qualification. And he did not get selected in that minimum.
yes. we held the examination, written test. Written test, he got third.
Huh?
He got position is third one.
Oh, then he has a good case. Did he pass the minimum qualification only?
I don't, your lordship can you, that is what, in this rule, my lord, there is no criteria to assess the minimum.
No, I'm not on there. Seniority come merit is the criteria.
My lord.
If it is a seniority come merit, then for suitability,
Fine.
you can have an exam that whether that person is suitable to go to the higher post.
Fine.
And when you have that suitability, then you may have a benchmark.
My lord.
Now, did he pass the benchmark or not? That is the only question. Once he passes the benchmark, matter is over. His seniority will take over.
My lord, here in this case, my lord, your lordship can be seen my affidavit, my lord, they decided to, my lord, held a written test.
Written states he is number 3 has no relevance. Whether he has crossed that minimum.
That is not decided. Because your lordship,
Then obviously, then the entire selection has to go.
your lordship kindly see the resolution. Page 47, your lordship kindly see. Page 47. Except to.
Yes. On recommendation of the selection by the committee, it also is noted
All
to
the
post of UTA to the
gate
VI
for employees of the establishment of district session, the double written test for the post of LDA. And maximum qualification mark will be 30. And that, so that resolution was taken by law and accordingly it was done.
How much marks did he get?
Mark, my lord, that affidavit or this not disclosed,
Huh?
but select list was, my lord, his position is third, my lord. How much mark?
No, how can he be the third? That question of third does not arise.
My lord, that's the procedure day, my lord.
You set aside,
My lord, I have not seen the record, my lord, but
not necessary.
so that is the.
Your compatriot, Mr. Critical, Mr. H.K. Das has enlightened me with the judgment, what is called that judgment. Where is he? The Karlar judgment. Where is it?
Yeah.
Now see, we thus arrived at the conclusion that the criterion of seniority cum merit in the matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority and a comparative assessment of merit is not required to be made.
Here is this case, my lord. The merit was decided on the basis of the.
We have
That
to
is the-
set aside. What is wrong? Judges, they don't know. You want to file reply? You want to file reply?
Sure.
Why? When the court is in your favor, why do you want to file a reply?
How,
I. Is your reply, let us see. To say the facts are not correct, mandate of the rules have been complied with in letter and spirit by preparing the solution. What is this? Until.
that anything decided on the basis of the written test?
Huh?
Anything decided on the basis of written test?
You can have a written test for the purpose of having a benchmark. Okay, if you ask this, then we are going to consider. It was the question. Who is the private respondent? Yes, what do we have to say? Nothing. What do you have to say? You can't say anything. Huh?
It was determined on the basis of the encroachment. If we keep not taken.
You better go to the government. Tell the government that to frame the new rules of 2025 and making it merit cum seniority. Okay. Till then, government does not do it, we are to set aside your appointment. Now, you have challenged both. When was these people selected? Huh?
15/1/22.
In one. Where? Where is the impugn order? Impugn order. Oh, selection. You have been appointed? When? Merit wise. Thank goodness. Huh? Where is that order? You have not filed affidavit? Not necessary. You have challenged the selection, 18/1/2023, thereupon appointed.
What do you think?
Now, let us see the select list. Where is the select list? grade 4, Dhubri, huh?
Madam.
You go as, what is your name? Your name? Raju Borbuzari. Where is he? Select list?
Serial number 3, Lordship.
Of,
That is gradation.
Grade XMD.
huh? No, no, it's okay. But I think these are the, yeah, 1 to 8. 1 to 8.
Serial number 1, Lordship.
Nizam Hussain and Suman Kumari. Okay, okay. Now we have to set aside everybody. I thought that if one is above, then okay, one can be, but you see, they are, this is in as per seniority, annexure 2. Nizam Hussain, that is some respondent, is number 4, and Suman Kumari is number 6. So we have to set aside.
That is gradation list, madam.
Huh?
That is gradation list.
No, therefore,
Except he is the selection.
no, that I know. I'm saying that is only one person who has approached. No?
But-
Would I have saved one appointment, but I can't. It is my opinion.
Madam.
Because the other two is also much below.
Yes, correct.
So the entire process is
Eight
heavy.
candidate called for, out of 8, 488, out of 4 minor, this is the full. The base 23 man, those who are 88, these are the minor department. 88.
But then in that regard, can I save the appointment of this Nizam Hussain?
Madam.
Taking into account that there were 4 who have been appointed and have only participated
Participate out of the
out of 8. So others may have waived.
12, they are not a player.
Now, Nizam Hussain is senior. Maybe he is
Nizam
junior to the petitioner, but he is otherwise senior.
Correct.
Then number 6 is Suman Kumari. And number 7, the 4th one, is Konok Ray. Konok Ray is junior to even Suman Kumari. If that be so, can I save Nizam Hussain?
Out one.
Huh?
Out one.
One can be saved because only 4 participated.
Minor.
It is seniority come merit. It's okay.
As per will.
The manner in which it was done, it was not proper. But out of the 4 who participated, one was this number 4, number 1, number 4, then number 6 and number 7. Kindly come to page 22. This must be as per the seniority.
Okay.
So, number 1 is should have got it. I'm not on that. He's junior. He's bad. But the other is 6 and 7 because there out of 8, only 4 participated. The 7 who is there is junior. So can I save 1?
Yes. That Kanak serial number is.
Mohan Kumari and Ono, they were appointed the same day, 2013, 30.
Who?
30. This Mohan Kumari and Ono.
But Suman Kumari is above. The Suman Kumari will go, but not, because when the advertisement was issued, only 4 participate. Out of the 4, one is number 7, one is number 6, one is number 4, and one is number 1. You are number 1. He is representing 4 and 6. 7 otherwise also cannot have expound anything because he is junior. Let us set aside.
Go for it, please.
Huh?
Go for it, please. Say the sir and go for it, please.
This fish.
So the procedure is,
Help me set aside. There was no stake.
there is no state already there. They are for good common assignment.
Huh?
Respondent were for.
Subject to further orders. No stake. Set aside. What do you say? Support one of them. I am trying to support one of yours. This is what I am saying. Make submission to the effect.
This one can be saved, but
That is what I am also saying. How do I submit when the entire selection thing is wrong?
it's much more than 30%, 13. It can be. I think now.
Can save one.
From the depth, we my lord. That is one can be, it is a certain that my lord, all the 4 my lord, they got the best. So 3 name appeared in the wait list. That meaning thereby my lord, they got the best. So
So, if
that,
you can-
then seniority will come. Then seniority will come.
Seniority, other two who did not participate.
Either 4.
He is one.
He's one.
2 and 3 did not
Like yes,
participate.
yes, he's other goal there. Yes,
He is one.
he's one.
Number 2 and 3 have not participated.
2 and 3 not person. Yes.
4 have been given an appointment.
Hello.
Who is otherwise number 2
Yes. Otherwise number.
as per seniority list. And there were 2 posts.
There are 2 posts and there are a panel of 4 and on basis of merit, 1 and 2. That is there.
But then
Candidate,
also,
that candidate
as per
kind of-
seniority, I think one could have been saved. One can be saved.
One can be, but because he's 2007 and the person who selected one, that the person number 1 is 2009 and other is 2013. So 2013 will go.
2013 will go.
Definitely he will in. He will in. He will include it.
Oh, there is a question out there. There is another question. Why there is a problem which he is also not seeing. Problem is, as per clause 12, rule 12(2), the municipal rule. It is 12(2). Will lose his further seniority later. Very happy at all. Tomorrow your client will get hold. Because the seniority will be added
As
from
per
the
the
UDA,
Then,
then he will lose it. Because his selection will come later on.
Yes.
Because I'm setting aside, so now he'll be selected, but that person, if I don't touch, his selection becomes above, and thereby he lose his seniority in word.
Yes. Yes. So what is the? What?
In upper division, including Semester or Munship, the seniority shall be according to the position in the select list from which the promotion to the post of AI is made. So therefore, his select list is already done.
Yes.
He's already selected. If I don't touch that, so his seniority will be counted from then.
So he was,
And thereby he will forever lose the seniority
Yes,
to
never
get a
die.
further promotion to court officer.
the UD. The LDA UD.
EDA, then he will become a court officer, na? And experience.
Up to both of us. Yes.
He said that.
UD का.
Let them do it. Yes, you are appearing. That PR Bugoi appears after respond. As the appears for respond. 7. Petitioner. Herein. Have assailed the selection made in favor of the respondent numbers 6 and 7 by the select list dated 18/1/2023 on the ground that the respondents, more particularly the respondent numbers and 5 had applied a yardstick which is not in conformity, have applied a criteria which is not in conformity with the Assam District and Session Judges Establishment Ministerial Service Rules 1987, for short, the rules of 1987. The case of the petitioner herein, next day, is that he was appointed as a process server against the sanctioned post at the establishment of the district and session judge Dhubri by an order dated 19/1/2007. Subsequent to joining the services on 22/2007, the petitioner claims to be performing his duties to the best of his ability and satisfaction of the authorities concerned. On 9/2/2007-23, no, at this stage, this court finds it pertinent to take note of the gradation list of the office of the district and session judge Dhubri. of grade 4 bracket process server for the year 2021 enclosed as Annexure 4 to the petition. From a perusal of the same gradation list, it is seen that the petitioner is at serial number 3. Whereas the respondent, where are those others?
Serial 12 and 15.
Where at serial number?
12. Next page, Joseph. There.
No. Serial number 12 is on Ganesh Road. Where is the Nizam?
Next page, Joseph.
Huh?
Next page of serial number 12.
Where serial number?
Nizam Batin.
Where is the petitioner?
Petitioner name is additionally serial number 3.
No. Kindly come to pay Annexure 5. Where is the petitioner's name?
So annexure 4.
Annexure 4, I have the petitioner's name.
Yes.
But what about the other two names?
And that two, my lord, that's 12. Serial number 12 is 25. 12 and 15 minutes.
But in page 12, page 25, there is no mention of petitioner's name. Why?
That is office of the district and session judge, Joguri gradation list of the staff of the
Grade 4. And this is for process
First
server.
one is processor.
Before further proceeding, it is relevant to take note of that the petitioner herein was appointed on 2/2/2007 and he was confirmed on 22/10/2014. The respondent number 6 was appointed on 17/9/2009 and was confirmed on 15/6/2018. 18.
18. In 6 to
The respondent number 7 was also appointed on 15/7/2013. Was appointed on 15/7/2013 and was confirmed on 15/6/2018. Proceeding further with the facts involved in the instant proceedings, it will be seen that on 9/1/2023, the respondent number 5 had issued a notice wherein it was mentioned that on the basis of a resolution adopted in the meeting of the selection board dated 5/1/2023, the various grade 4 employees, 8 grade 4 employees, were called for interview, called to appear before the selection board for written test on 12/1/2023. It is seen further that the materials on record further show that on 18/1/2023, a select list was prepared, bracket, merit-wise, wherein the respondent number 6 and 7 were put at serial number 1 and 2, whereas the petitioner and another person, namely Sri Konok Ray, were put at serial number 1 and 2 of the waiting list, bracket merit wise. The petitioner being aggrieved on the ground that that he being the senior, his seniority was not duly counted, has approached this court by filing the present writ petition. Full stop. This court finds it relevant to take note of that by an order dated 13/2/2023, this court had issued notice and further observed that the promotion given to the respondent number 6 and 7 shall be subject to further orders that may be passed in the instant proceedings. At this stage, it is very pertinent to take note of take note of that during the course of the hearing, Mr. T.J. Mohanto, the learned standing counsel of the Guwahati High Court, have placed before this court an order dated number 8, dated 21/2023, whereby the respondent number 6 and 7 were promoted to the post of LDA on the basis of the selection select list prepared on 18/1/2023. The said order is kept on record and marked with the letter X. The record further reveals that by an order dated, reveals that the respondent number 2, 3, 4, and 5 had filed an affidavit in opposition through the district and session judge Dhubri. The said affidavit is very relevant to take note of the manner in which the selection was conducted by the selection committee, and on the basis of which the select list, the impugned select list, was prepared. At paragraph number 5 of the said affidavit in opposition, though the district and session judge duly acknowledges that the criterion was seniority cum merit in terms with Rule 6, bracket 5, bracket small c of the rules of 1987. But at paragraph number 7, it is seen that the selection committee had given a clear go-by to the criterion for selection, that is seniority cum merit. This aspect of the matter would be clear from a further reading of this aspect of the matter would be clear. Further clear. From a further reading of paragraph number 6 or 2, 6 or seniority cum learning. But at paragraph number 8, 7 number 8. Very clear. From a perusal of paragraph number 8, which should show that instead of having a minimum qualification, instead of adjudging the minimum necessary merit requisite for efficiency of the administration, the respondent selection committee have conducted a test, written test, wherein the petitioner was found as serial number 1, whereas the respondent number 6 and 7 were found at serial number 6 and 7, at serial number 1 and 2. There was found serial number 3, whereas at the respondent numbers 6 and 7 were put at serial number 1 and 2. So, at this stage, this court, taking into account the manner in which the selection committee proceeded with the selection, finds it relevant to take note of the judgment of the Supreme Court in the case of D.K. Sivaya versus K. Adanuddin Babu, reported in 1998 6 SCC 720, wherein the difference between the principles of merit cum seniority vis-a-vis the principle of seniority cum merit was explained. It was observed by the Supreme Court that where promotion is to be based on principle of merit cum seniority, a greater emphasis is laid on merit and the ability of the candidate, and the seniority is to be given weight where merit and ability are approximately equal. Whereas, when it comes to the principle of seniority and merit, the promotion is to be made on the basis of seniority alone, subject to having the minimum requisite merit and suitability of the candidate amongst the eligible persons. The Supreme Court further observed that the principle of merit cum seniority postulates the requirement of making a comparative assessment of merit, whereas no such comparative assessment is required where the criterion for promotion is based on the principle of seniority cum merit. It was further observed that if the candidates have the same length of service, it is only to be determined where the candidate possesses the minimum required threshold of merit or not. The Supreme Court further observed that the criterion of promotion that where the criterion of promotion is principle of seniority cum merit, marks can only be prescribed as a minimum qualifying requirement, and as such, where promotion was being given to the eligible senior most candidates on the basis of their individual marks, such promotion could be contrary to the principle of seniority cum merit. This court further finds it relevant to take note of, taking into account the above laid down principles by the Supreme Court in the case of D.K. Sivaya Supra, and the manner in which the selection was carried out by the respondent selection committee. This court is of the opinion that the criterion so adopted was merit cum seniority, but not seniority cum merit seniority, which was not the criterion for the purpose of promotion, which is seniority cum merit. Consequently, the entire selection so made is on the basis of and being contrary to the provisions of Rule 6(5) bracket C of the rules of 1987. The entire selection so carried out, the selection order, the select list dated 18/1/2023. As well as the order dated 21/2023 kept on record and marked with the letter X are set aside and quashed. Are required to be interpreted. In view of the above analysis and determination, this court therefore disposes of the instant with petition with the following observations and directions. Number one, the select list dated 18/1/2023 impugned in the instant proceedings is set aside and quashed. Number two, the consequential order dated 21/2023 by which the respondent number 6 and 7 were promoted to the post of lower division assistants is also set aside and quashed. Number 3, the respondents, more particularly the respondent number 3, 4 and 5 are directed to forthwith take steps for filling up the posts of LDA by following the by way of a proper by way of by a proper by us by carrying out the due selection process is problem. All right.
So if you find an affidavit also, the statements are very incorrect, Your Lordship, because they filed an affidavit also with the forest department, and which we believe that the statements are very incorrect. Because, Your Lordship, in that report, or if they submitted a report, which it say that few of that most of the camps are not functioning and dismantled. My lords, court that will bring on record certain documents also where it shows that those camps are actually functioning, Your Lord. My lord, I had to answer something. My lord, perhaps this will go to a PI. There's a connected PI, my lord, PI 78/2018, filed by one entity called Early Birds, wherein, my lord, there's a direction from this court to that Nameri area also, to, my lord, to carry on, my lord, and this. To carry on, my lord, anti-encroachment drives, my lord. That area, that in that we have been passing orders, my lord, and we have been formulating plans, my lord. That area also comes in, that Nameri camp, and it's a part of Palipara Reserve Forest. Division bench has been monitoring that matter. My submission is that it's an individual matter, lordship has, lordship, it's an individual matter. If the matter goes to division bench, it's a forum, your lordship, firstly. Firstly, we use a forum, lordship, even the state also uses a forum.
No, the submission is making the for the making that submission just for the sake.
No, no, my lord.
It's for me to consider.
Yes, lord, I'm not, that's for the sake of my lord. I'm making it.
He has to make that submission, so he's making it. The question is for this court to
Yes,
consider.
lord, obviously. Madam, recently we have digged out this, my lord.
Huh?
Because recently, my lord, directions were passed by this, the division bench, my lord, to formulate plans and to carry out evictions and clear out that area, my lord. Sunai Rupai Wildlife Sanctuary and Nameri Landscape, my lord.
We'll remove it.
My lord.
Remove those.
My lord, plans have been formulated. We have submitted those plans to the division bench. A total method area now for the timing, Sonai Rupa is on the scanner and Ameri also plane is on the formulation. This area has also comes under Ameri. Bali
I've
Bali.
asked them to file an affidavit, where is that affidavit?
Well, additional affidavit I have to file number. On 13/11/2024. Start from page number 307. 307. If we exclude the index bill. Comes to page 320.
What affidavit I asked was
Specific, my lord, specific lordship will see the order dated 26/9/24, my lord. The paragraph 4. Certain camps were named and the response was asked what we did for that against those camps. Right?
What is your reply in which paragraph?
Well, we have filed a reply. And my lord,
Paragraph number?
a report, my lord, status report of reply.
Paragraph number?
That lordship's order in page, paragraph 4. Specific some certain camps again. Page 314, you know.
T1,
4. Then the report starts at 316.
no, I have asked you as regards those various resorts.
Yes, 316 page number. We have compiled a chart. Lalimo camp, White Wing camp,
Where?
Elephant Paradise, Victoria camp, those camps.
Where?
Page 316.
Even 6 I see only ecotourism versus vis-a-vis section 2.
My lord, this page was 316 annexure B of the affidavit.
When did you file that affidavit?
It was filed in page number to move in, you know. Affidavit number extra number, no? The month of November. Oh, this one.
Ah, those pages are wrong.
Oh.
How is the Assam Tourism Department personality cottage functioning?
My lord, they function on their own, my lord. Perhaps
Oh.
that I have to take instruction because that's
maybe they have been given a allotment by the government.
How?
That
If it is a non-forest activity,
well,
if it falls within that area, well, this report categorically shows that all these things falls within the area of the tiger reserve.
Right.
How is Prasanthi Cottage?
Prashanti, my lords, as far my knowledge goes, my lord, it's not running in a running condition.
You say that it is running.
Running means, my lord, it is established under the, this
No.
Assam Tourism Development.
This is the report of the running.
Then these I have to take specific, well, how it is allotted to them. How it is allotted to them, I have to get specific.
Not allotted. How are they functioning? That is the important. I'm not concerned.
They are not, they function, my lord, in their own independent way, my lord.
How?
My lord.
If it comes within the tiger reserve forest, for which you are not even permitting them to have an ecological reserve, then how is that resort functioning?
They might have permissions, my lord. They
From
necessary
whom?
permissions.
You have to take the permission from the central government. Have you taken the permission?
That I have to see, my lord. I have to seek instructions on that aspect.
Thereafter,
But my lord, that aspect will be on
Tuesday.
the day after.
Tuesday.
Oh, okay. Tuesday. Ah, okay. But my lord, that aspect will do something. I'll not do consider, my lord. That PIL, I'll bring that PIL. That PIL which I've said, my lord, it covers the Nameri specific area. Their directions have been passed to undertake, my lord, anti-encroachment drives, my lord.
Mr. Gogoi,
No, it's not that, my lord, I'm trying to,
I'm not on that.
my lord.
Can the single bench transfer a matter to the division bench?
No, perhaps, my lord, you will consider, my lord.
No, I would not.
My lord.
I cannot.
Because
Unless you
other-
get an
One hand, my
order,
lord, in the PIL,
unless you get an order from the chief justice on the administrative side. Or in the PIL, this record of this case is taken away. Without that, it is not possible on the part of this court. I don't have.
I
the
understand, my lord.
jurisdiction.
I found my answer. I'll do the needful.
If you want to
I'll
make
do
that submission, you make the submission before the division bench or the chief justice of the administrative. Side.
My lord. I'm doing the needful.
But we'll have it on next Tuesday. How is Prasanthi Cottage running?
My lord.
Because nothing can function.
Yes, yes, yes. Everything goes. We agree
Everything
to
has
everything goes. They also go, Prashant also go.
continue. Because this cannot happen.
Yes. 2 years.
It's the matter again on 29/4/2025, on which date Mr. D. Gogoi, the learned counsel. Now, pursuant to the order passed by this court on 26/9/2024 and 4/11/2024, the Divisional Forest Officer, Honipur West Division, had filed an affidavit enclosing a report dated 12/11/2024. In the said report, it is mentioned that Prasanthi Cottage, which is a resort oblique dhaba, is running under the Assam Tourism Department. This court inquired with the learned counsel appearing on behalf of the Forest Department as to whether any specific permission has been taken from the central government in terms with Section 2
Yes, sir.
of the Forest Conservation Act 1980 for the running of the Prasanthi Cottage within the Nameri Tiger Reserve Forest. He submits that he would take instruction and place it before this court on the next date. This court further takes note of Taking into account the above, Mr. Smatter again on 29th of April 2025 for further instructions.
This is APTC, madam, Assam Tourism Development Corporation. It's not,
He mentioned it Assam Tourism Department. I am not.
The interim lordship will also bring on record lordship that some of the other camps are also functioning, your lordship.
You can on record,
Yes,
we'll put some photographs.
Lovely.
We appoint some commissioner to find out as to whether it is at the cost of both. Ask Mr. Harbour Pujari to go there. There is good in America.
Item 5,
Yes, what is this?
Matter related to the pensionary policy of the petitioner, my lord.
Huh?
He was engaged in a federal employee, 1998, and thereafter on the transfer of his officer, he was also transfer of the defined district. And ultimately, he has got regular employment in 2005 in the district of Kolkata, my lord. That is one. Tell me, my lord, one 12/2005, the appointment was regular, my lord. And thereafter in 2007, he has applied for the, applied for the opening the pension policy, my lord. And actually, the government has introduced the pension because deposited the pension at the rate of rupees 2007 to 2023 month. In 2023, he has written a letter to the district judge and that for the issuing direction to the petitioner to make the final withdrawal of the pension benefit, all pensionary amount, because as his appointment was regularized after 1/2/2005, he is not entitled to old pension policies, my lord. But
You were appointed when regularized?
he appointed. Regularized, my lord, 1/2/2005, my lord.
You were regularized on 1/12/2005.
2005. But we were
And
working for
new
98
pension scheme came up on 1/2/2005.
That is, he was appointed in, he was 98, my lord.
As what?
From 98, he was working as contractual basis, regular basis.
No contractual basis, no business.
No, the question is that. Question
No
is that they
business
were,
of being in contractual basis. Were you appointed freshly?
I,
However, you were appointed, regular scale?
they are the case law, there is a case law that the person appointed after 2005, but working. So working prior to that are entitled to the old pension, my lord. I have submitted one additional affidavit, my lord, on the additional affidavit on 27/6 to. Not 27/6. My lord. 21/6/2000. 11/3/2024, my lord, giving some documents that the most of the employees regularized after 2005 are entitled to regular pension.
Where?
But these are not recorded in the order. And the 11/3/2024, I have filed an additional affidavit with some document. By RTI, the petitioner has obtained those orders from a different department and will regularize after 2005.
Where is it?
But here also can you see the, my additional affidavit 11/3/2024. 24 here, my lord. Here my, it is made, people, RTI information, my lord, RTI is a different department. Here, my lord, Vipul Kumar, the submission of RTI report, page, my lord, 64. With reference to the subject, I have the honor to submit here with the reply as sought for RTI Act 2005 for favor of kind provision and necessary action, my lord. That is, you have found the applicant Vipul Kumar, son of so and so, Kolkata, history, Kamapur, so and so. The question number A, how many temporary contractual and master road workers were regularized during the period from 1/2/2005 to 31/12/2005, my lord? as per declaration made on 15/8/2005 by the Chief Minister. So, answer, altogether 149 employees were regularized from 1 to 2005 to 31/12/2005 as per above declaration. B, in respect of.
So
the
you,
employee,
Mr.
what type of
Sharma,
refund is
Mr.
what-
Sharma, you want this court to follow what the executive engineers are saying.
And the
You were not regularized. You were freshly appointed. Show me your regularization order.
is page 33 in my petitions. Sorry, Vipul Kumar, money of wages employee under the establishment of the judgeship of is transferred and appointed peon temporary basis and office peon in the office of the district and session judge Borvata against the vacancy created for promotion of the city, Sri Rajan Das in this case of case so and so. He directed to report of his joining with immediate effect from the date of receipt of the assignment. That is 1/12/2005.
It is 112. How is this
112.
person appointed?
In 2012, my lord.
How is this person appointed like this?
My lord, I should not say so, my lord.
It is
But
illegal
the-
appointment.
My lord, let my learned counterpart. I
Was he
should
the
not say
district
so.
judge?
Yes. He had given the initial appointment. Kindly come to my lord, page 23 of the report. Let us see. Even page 33 also. It is. Kindly. Kindly come to my lord, page 23, annexure 1. Let us see the sequence of his engagement, my lord. Sequence of engagement of the
He
petitioner.
was again defined district in defined capacity on the
My
transfer
lord,
as
this
officer, my lord.
this is the first letter.
Because approximately
Shri
district judge.
Vipul Kumar is appointed temporarily as Mali on wage basis as fixed pay of with effect from 16/1/98. Then Lordship may kindly come to page 25. He is appointed temporarily as Faras, casual employee with effect from 4/2/99. Then my lord, my learned counterpart, my lord, when he was here, my lord, he was transferred as presiding officer, industrial tribunal. He carried along with him the writ petitioner wherever he went, my lord. And this is how, my lord,
That's why
he was engaged.
going on at that time.
Page 27 then page 27. Page 27. Then page 29. Page 29. Scale of pay is given. How, my lord? Scale of pay is given. Kindly see. Page 29. Page 29. Vipul Kumar so and so is appointed temporarily as peon attested in the scale of pay without there being, my lord,
And he has been promoted also.
promoted. Kindly see further.
Every district he was appointed given for.
Kindly see further, my lord, page 31. Page 31. Page 31, my lord. In the interest of public service, Vipul Kumar the petitioner is appointed so purely on temporary basis as Mali. The expenditure will be debitable from the major head so and so.
So here, from here, he goes to Borpeta.
Yes, perfect. In between Gulaghat, industrial tribunal, everything. Everywhere. And wherever Planet district and session judge was transferred, he carried along with him, my lord, the
That process
petitioner.
was going on at that
And
time.
my lord,
That is not my fault.
one after another, my lord,
This
this
employee who was attached with the officer.
engagement letters
on his
came to
transfer, he
be
was
Mr.
taken as
Sharma,
officer.
I think you should not appear. Ask somebody else to appear. You don't appear. Who are the main respondents?
And respondent, my lord,
You are the main respondent. You don't appear.
Now, my lord, he is.
You get hold of your person to appoint somebody else as some other lawyer or ask him to appear. It would be embarrassing on the part of this court to make comments.
Now, my lord, I am confirmed with the regulation part.
There's no regularization. The regularization, whatever may be, the question has been done is okay, but you are not taking into account that you came into service only on 1/12/2005. And from 1/2/2005, you were brought within the services of the state. What has happened to my old pension, new pension judgment? Anything set aside?
I think, I have kept it ready, Purnima, correct?
Then
No, it is that
I have
I
already
I
delivered.
asked him to engage that way. Now, my lord, they have filed the affidavits. I pray your lordship to allow me 3 weeks time to file the reply.
No reply being made. This type of cases should not. You were lucky enough that the earlier judge
They
has
have
given so
filed
much.
affidavits, my lord.
My lord, 1/12/2005 is not a regular appointment. 1/12/2005, that
Yes,
my lord
it was
ordered
regular
at
appointment.
page 30. But this is not so regular. It is just a continuation of his engagement. There is a break in service. It is stopgap arrangement, my lord. No, it is carried out.
Stopgap, my lord, stopgap not. It was on the third officer.
Now, are you getting the salary or not? Have you retired? He has retired.
He is still in service and in the,
Salary.
he has approached the honorable court. There, my lord said that, my lord, that order lordship will
Now, my
find,
lord,
my
by
lord,
this
at
time,
page
by
49.
this time, he was
Kindly see,
promoted
my
to,
lord, page 49.
by this time, he was promoted to lower division assistant.
Page,
Now, he is
page-
working
page
at Amingaon,
49.
my lord. Amingaon as LD, my lord. In the third district and session of Amingaon, my lord.
page 49, lordship will kindly come to, my lord, page 52, paragraph 6. Page 52, paragraph 6. What was the nature of relief claim? Being aggrieved by non-payment of salary, the writ petitioner has
lordship have
approached the court seeking appropriate direction in the matter of payment of his salary. Payment of
When
his
he was
salary.
given the appointment, he was not given salary or his petition was filed, and the honorable high court has directed to pay the salary. And accordingly, it is all
There-
on record, my lord.
My lord, page
So by
56,
virtue of his order,
page
the
56,
high court,
paragraph
he has
11.
got regular appointment, my lord. So only point is that he was regularized on 1/5/2012. And according to them, the 1/2/2005, thereafter, 1/2/2005, nobody will get that, old pension policy, my lord. But those thousands of employees are getting this benefit, my lord. I am filing these documents, my lord. Now, who has appointed him, that is not the question, my lord. When he was regularized, that is the question.
Then what happened?
Then, my lord, page 56, paragraph 11. Page 56, my lord, kindly see the direction. That for payment of salary, concurrence of finance department is not required. So you pay the salary. This was the direction. Now, his was, my lord, confined only to payment of salary, which means happily received. There is no, my lord, allegation in the present. Here he is seeking, my lord, DPF. He says, my lord, that he has taken some money on account of DPF, which was sought to be recovered, my lord. There, at page 57, kindly see, my lord, page 57. Page 57.
He has been paying the provident fund money since 2007. But after 14 years, AG had issued notice. For last 14 years, they were sleeping.
And in between, lordship may kindly come to page 46, my lord. Page 46.
Then what happened? Now, what is he asking for here?
He is asking for, my lord, for setting aside, my lord, that annexer 8 and 9. Annexer 8,
It is what?
yes, annexer 8, my lord, at page 46, annexer 9, my lord, at page 47.
Then what happened? Now, this document is for the purpose of what?
Now, here, my lord, this is a communication, my lord, by the accountant general to the learned district and session judge, Batale, my lord, where it has been stated, my lord, that in pursuance of my lord, a communication, my lord, issued by the Finance Budget Department, my lord, where possible recollect, my lord, that for all NPS category, my lord, persons, PPF is not applicable because they are getting double benefit. It will entitle to double benefit. So PPF will not be applicable. So here, my lord,
Then there is also another notification. There are two notifications. And 2005.
yes.
Two notifications, if I remember. You have the judgment, I have mentioned it in
Yes,
my
I do.
judgment.
That the lordship has quest that 2010 communication made by finance budget to my lord, the accountant general. That is 2010.
No, 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 no. There are two notifications given on 1/2/2005.
Yes, pension.
First is there's an amendment.
Yes.
See
Amendment.
that?
Yes,
There's an amendment.
yes. That lordship will find. Yes. And we see. Yeah, only it over, my lord.
They have amended two aspects. One is bringing in Rule 2A. And there only it is stated that there is no question of any GPA.
Now, I could have, my lord, perceived the situation where his appointment is regular or he is regularized. Then, my lord, perhaps he will be entitled under the NPS. Here is a case where the petitioner is not even entitled to NPS.
But he has been paying since 2007. They have issued notice in 2023 after 14 years. Now. But this is circular 2012, which they have referred to.
This is one, and here, the next one, 14/11.
Yes, fine.
14/11/2011, 14/7. In pursuance to the approval of the government cabinet held on Iman and in exercise of the powers conferred under the proviso to Iman, the governor of Assam is pleased to make the following rules further to amend the General Provident Fund Assam Financial Rules 1937. In the principal rules in Rule 4, after proviso to the following, provided further that furthermore that the government servant appointed on or after Iman to the services of post in connection area which are born area where they shall not be eligible to join the fund. So this notification is there of 14th of July 2011 without there being a challenge to this. How can I pass any order?
Yes,
Matter over.
absolutely correct. Then another thing, my lord, it says that, my lord, government servant entering into service, meaning thereby, my lord, it is a regular appointment.
Therefore, he entered into service on 1/12.
2005, very regular appointment.
This, therefore, my lord, page 33 is not a regularization or regular.
Understood, but
Yes.
then also for all said and purpose, one can only say that he has come only after 1/2/2005,
Whatever may be. And
after 1/2.
Yes.
So therefore, he has joined. I would not put the date because if I put the date, he will be further harmed. I would not like to put the date. But is 1/2/2005, thereafter he cannot contribute to the GPF. Now, if any amount has been contributed, has to be refunded by them. And has he taken that amount advance of 70,000?
that, my lord, perhaps
He communicated with the office that he filed the requisition before the honorable court. So he may be given time to withdraw them. He did not withdraw them.
So he doesn't have. So now if there is any amount taken by you, you have to return it. The accountant general, who is there? You will have to return it to him. How you do it or what is the manner, what do you do? There is also another notification to that effect. Who have subscribed, what is the consequences?
that lordship will find, my lord, I have kept that window open, my lord, that tablet lordship will find it, that the notice, that communication, my lord. Communication from budget to accountant general, finance budget to accountant general. I have just scanned it, my lord. It's a part of the record, my lord.
No, I have also mentioned it somewhere in my judgment, if I'm not.
That, my lord, flag X of my lord's record, my lord. Flag X, here in my.
I give it. Oh, yeah.
It is there, but the flag X. That is the communication, my lord. By dint of which, my lord, that is the communication by dint of which, my lord, the Office of the Accountant General has
This
undertaken the
provision
assessment.
that
Yes,
will
my
be
lord.
given that PF will not be
That
applicable
acts.
for some people. It will be refunded with interest up to the month preceding the month of issue of authorization of the deal, so and so. Therefore, request you to kindly. Now, it was therefore, this, I think, flag X.
Flag X, that's what.
So you were supposed to return in the year 2011 itself. But you are still continuing to take in 2017 also,
No,
page 45.
page 45. 2017 subscription, yes. So for the latter part, my lord, post my lord 2011, he will not be entitled to interest. This is what my lord, this communication says. It has to be refunded. It is his money. It has to be refunded. But for wrongful detention, my lord, he will not be entitled to, my lord, any interest. My lord. If it is, my lord, assume that there was a wrongful, my lord, retention
My lord,
of that
other
money.
thousands of employees are getting those benefits, my lord. I'm submitting all the documents. And there is a case law also that is attached holdings. Yeah, what is their logic? It was notification
Now
issued-
kindly see page 41.
Page 41, my lord. Yes, my lord, 2023 also.
Why are you taking?
It's a statement.
This ought not to have been, my lord.
Huh?
It ought
Up
not
to
to have been.
2023.
Who is it? Who is taking senior accounts officer? DDO has done it. You have done the problem. So therefore you have to pay interest. On this amount, he has to get an interest. When under law he cannot take it, then you have to return him along with interest. This interest at 7.1%. So why have you taken that money? You should not have done it when there is a notification. There's not a notification, it's an amendment to the pension rules.
Yes.
You have to pay that amount along with interest. Return it along with interest. That notification of 2011 could not hold water to allow you not to pay. You return that amount and the interest will be paid by the DDO.
But they are holding the money.
You,
Deducted.
how
That's-
you work,
that's-
how you work
them.
out is another thing. Why on earth did you do it? You are not supposed to take that money. Person who has been deprived of this 2,000 rupees per month. What is his salary? Here you are taking money. Earlier 3,000, now 2,000. And you have given an interest rate. This is done by the Office of the Accountant General, 7.1%. It is you have given this declaration at 7.1%. You have to pay. Page 41.
This program also that is the deducted, but the amount is deducted by the authority.
Understood. Why have you kept it? And you say out here interest rate from 4/4/2000 at 7.1%. You pay that. You have given that undertaking.
Lordship, this is, lordship to video lordship.
Huh?
Video lordship, video lordship, upper one lordship, video, chief Godali lordship.
No, here you say Asin Biswas Senior Accounts Officer, PF. See this. Office of the Principal Accountant General. This is your thing.
Yes,
Yeah.
That's statement, lord.
Understood. In that statement, you have put it at the interest at 7.1%. He has the interest rate. Right, you have retained it, you have given an undertaking that I'll return you. This is an amount which has been given by the state, you have taken it as a state. He was not entitled to deposit. He should not have, and the DDO ought not to have deducted. He did not do it by himself. The DDO did it and gave it to you, whatever may be, and then you acknowledge it. Why didn't you act in terms with that document, that the amendment which was made in the year 2011? Forget about your affidavit. I'm not concerned with so much of affidavits. The issue is very simple. You return it along with the interest which are being given as per the statement.
That is for finance department beginning, because we are holding on interest. That amount is deducted by the DDO lordship. That amount is deducted by the DDO from the seller.
DDO deducts who holds the money.
We are holding that.
What are you doing with the money?
Because we have
No, what are you doing with the money?
in our account.
Why you are keeping it?
In the account.
Does it lay eggs? Does it lay eggs? Then
Lordship takes 66, and extra one of my affidavit.
not concerned with that. To return it. No way out. Page 66 is different. Affidavit filed by respond number.
For my lord. 5.
What are you saying?
That lordship, the district and session judge lordship, then, on 30 August. Clarification regarding some. Yeah. The year 2020.
This is a letter written by the district and session judge, Bozali. Then
Clarification given lordship and third.
you have given the clarification. Why did you accept the money? At one hand, why do you accept the money? Why didn't you immediately tell them that don't do it? Is the accountant general not aware of the provisions of pension, GPF?
Department is 69 lordship for the year. In the year 2011, finance department has written a letter to the all of the department, but not to that lordship after 1 to 2005.
Then why did you keep it? Does the only law apply to the DDO, not to you? Then why did you keep it? That is why I'm asking, what do you do with the money? You are a state, you are responsible to pay that amount. How you pay, that is your lookout. You have to return that amount. Or give a declaration that you are going to give him the GPF.
Lordship, we are the not offering.
I don't know.
That department is the.
No, you want to save yourself with the interest, then give him the GPF.
Department agrees then lordship.
Yeah.
We are the authorizing as a.
Not, I'm not concerned with state government agrees or not. You have kept the money. Did you not see this document? Why did you accept at all? Did the accountant general did not have the date that he was appointed on 1/12/2005? Then, because that letter which have been written at page 66, there is no mention. You can't keep up with it.
Second paragraph of the letter. Furthermore, if there are discrepancies for the employee not entitled to subscriber that we have, please let us know.
Where?
Page 66, second paragraph.
You have to pay along with interest 7%. Whoever pays it, you return that amount.
2011 will get it. Thereafter, any amount was there and by the finance for government.
Don't file appeal before the division bench. I'm going to pass an order to the effect that you have to pay.
But it is also deducting.
Whatever you do, all three of you, write it out amongst yourselves. Do whatever you like. Pay him interest. I'm not concerned. Why on earth did you issue this statement? Didn't you know that he was appointed on 112 when there was a rule out there? The rule have been amended in 2010. That is why it's 14/7/2010 or 11.
14/7.
That is why they have put it in the year 2011. There would not be any further interest to be paid.
Interest rate from 4/2022 at the rate of 7.1%.
Huh?
Versus that is 39 or 41%. That is from up to from April 2020 at the rate 7.1%.
What is it?
That is from April 2022 at the rate 7.1%. That is 41 liters.
I've seen it.
What is the basis of this?
What is the basis?
That is close.
Interest is very well clear. Anybody now who wants to go for a GPF has to pay the interest. He gets the interest. A normal employee who have done it, who were prior to 2005 in Assam, gets it. You have made the mistake. All of you, three of you, do whatever it is. You have to pay that interest. Return it. He's not entitled to GPF. But what happens? He gets the entire benefit now. Because of all of your failure. GPF is what? You put a particular 2,000, 3,000 rupees per month. So that at the end of the term, when you are going to retire, to get the said amount along with an interest of 7.1 or 7.8%, which was a very high interest at that point of. People get that, and more particularly at that point of time, what was happening, that this interest was not chargeable to income tax. That is why all these government employees used to do it. It is only around 3-4 years back. Now, on the interest component, there is a income tax being imposed. That is why people keep in the GPF. Isn't it? Now, when is he going to retire? 79. Date of birth. How many years are there?
2029.
Yeah, it can't be 2010. 29 will be only 50 years. 39.
39.
So he already has got the benefit from 5. He has kept him from 2005, 5 to 25. 20 years interest you have to pay. You have to pay. Illegality of writ large of all three of you. It is not a notification. We are not concerned with the finance governance notification. We are concerned with the rule. The rule was amended. So there could not have been realization on the function of this GPF. And now also you are speaking. Have you stopped or not? Have you stopped or not? After 2023?
Latest, my lord, it appears from the repetition that till 2023, my lord.
Ah,
That's it, filed any application.
no, after the letter written by them, have you stopped or not?
My lord, we asked him to do the amount, my lord, GPFM. And by doing so, I don't have specific input instruction. By doing so, it means that we have solved.
Where is it?
I have not been.
Where is your instruction to that effect that, where is your written that you kindly do it?
Page 46, may kindly be seen, my lord.
Huh?
Page 46, which is put to challenge here in my lord. In the repetition.
This is a letter written by the senior accountant.
Yes.
47 maybe.
So at page 46, my lord, in the second paragraph, it is written, it is therefore requested to direct the subscriber, Vipul Kumar, that is the repetition, holder of DPS, to
But you
submit.
never know.
Yes.
These district and session judges may do everything. They can get it, this thing of feel, they keep on asking, seeking.
Finally, page 46.
In fact, Mr. Barbujari, I even don't understand the order of the division bench also. Now, without the finance concurrence, where is the question of making payment? It is impossible.
That's what,
This is the mandate of Article 229 and 235.
Yes.
As regards pay, salary, it is the duty that without the finance concurrence, how can there be a 202? Article 202 makes it very clear. This has to come from the consolidated fund of the state. Now, for that, there has to be a particular requirement of having a fund. For that, a bill has to be placed. A budget is to be made under 202. Now, without the finance knowing it, can there be? Then without the finance knowing, can these things be done?
then why,
With great respect.
yes, absolutely. Now, why,
This is an order which cannot be.
on what reasoning this order was passed? On the strength of the submissions made by the learned council for GSC, that at paragraph 9, kindly see, my lord, page 53. Page 53, paragraph 9, for my lord satisfaction.
Not necessary. They may say many things, 235, 236, ministerial, it will come in. But can the High Court make the rules? Even the High Court under 235 can't make the 309 rules.
So contrary submission was made here, that's why, paragraph 9, page 53.
Even for the Guwahati High Court also, the Chief Justice have all the powers, but for the purpose of pay, pension, everything, it has to fall back upon the government again. Otherwise, tomorrow, because even we don't, the High Court or the district courts do not get the money from the sanction from the, even for the court fee also, that amount goes to the consolidated fund. From where will the High Court earn to pay the salary? The state earns the salary, then cross illegal. But he has to get the interest. At the contractual rate of 7.1%. You only get the interest. Withdrawal with interest, nothing more than that.
Kindly see the other documents that I have.
I'm not looking into that.
Most of the employees are regularized after 2005 have been receiving the old pension scheme. My lord. I'm submitting lot of documents. So kindly give me that.
I am not
I
going
have
to
the
do
case
all
also.
these things. Mr. Sharma, I can only give you one opportunity to that effect that you will say that I am not going to appear, some other lawyer will appear. Because with that lawyer, I can pass some obvious observation as to how the appointment of the petitioner was made.
Till today, his payment is accepted by the government, my lord. The paid amount is accepted till today, he's making payment.
Is it?
Yes, okay, because he has filed an application before the district judge that if his petition is disposed, I may not be allowed to withdraw the amount. And he was allowed, and according, he is making payment this today. The document is necessary, I will bring under my step, my lord, along with a copy of the application. He filed a document, so that he is, for regularize.
You are saying that till today he is being depositing and they are accepting it. He's not depositing. No, he's not depositing. It is, you see, when you put your nomination or to that effect, the DDO deducts it. This deduction is done at source. So is the DDO still deducting it?
I have to take inspection on that.
Action is.
Possibly we are not,
Because,
because of that data which I placed.
yeah, my lord,
Mr. Sharma, don't make a statement. I will record it. No, I will record it. And that you are saying that they are deducting it still.
I may be allowed for 5 minutes time side contact with the client, what are his,
Okay, 2 o'clock.
I can confirm, no, what.
2 o'clock.
Is to one pertaining to Itanagar bench to remove PC for motion item 1.
May I lordship?
In pursuant to the order dated, my lord,
Mr. Chaudhary, I have also to deal with other benches for all the High Court matters.
Yes.
So therefore, I fix it at 2 o'clock.
Okay, right.
No, this is a different matter.
good, good. Sorry.
Yes.
May I lordship? Lordship, this is regarding upgradation of pay scale of the petitioner, lordship. Here, lordship, petitioner is serving as a record keeper in the Guwahati High Court Itanagar permanent bench, lordship. And lordship, as per the Guwahati High Court Service Rules 1967, in terms of the revised scale of pay, the existing pay scale of record keeper of Guwahati High Court Itanagar bench shall be at par with the pay scale of assistant of the Arunachal Pradesh Secretariat, lordship. Lordship will find the relevant portion of the Guwahati High Court Service Rule 1967 at page 26 of my petition, lordship.
Yes.
Lordship, this is the revised scale of pay, lordship. Lordship may kindly see serial number 8, lordship. This is the record keeper, lordship. And in the right side, lordship, it has been mentioned as corresponding to the pay scale of assistant AP secretariat, lordship. However, lordship, despite this, lordship, the petitioner is receiving a basic pay of rupees 35,000, which is level 2, lordship. Whereas his counterpart, that is the assistant of Arunachal Pradesh Secretariat, has been receiving a basic pay of rupees 49,000, lordship, which is level 7, lordship.
You have put something out here which cannot be seen also properly.
Pardon, lordship.
You have put it in something which can't be seen. It's so tiny. What keepers? Where have you got that document? Page 26.
Yes, lordship, page 26, lordship. Lordship, this can be found in, lordship, Guwahati High Court Rules 2002 also, lordship.
Where? Which book?
Guwahati High Court Rules 2002.
Court Rules of 2002. 22.
2002. At 405 page.
405.
Page 405, lordship.
2002. Na pre. About the first. Maybe report.
Done. Court keeper, record keeper.
Yes, Losip. At serial number 8, Losip.
19,900 to 63,200, level 2. Why you are referring to an old book? It has changed.
Let's say na.
It has changed. Have you got this book?
Let's take this.
Losip,
Now what is your problem? How much you are getting?
Losip, I am getting basic pay of rupees 35,000, Losip. Whereas my counterpart is getting basic pay of rupees 49,000, Losip.
Who is your counterpart?
The counterpart is part is Losip, assistant of Arunachal Pradesh Civil Secretariat, Losip.
Who is appearing for the state of Arunachal Pradesh?
I'm appearing, Lordship. For
How
one
do
to
you say
four.
that assistant to that is the record keeper here, please. Your name is what?
Sado Tangu,
That's
Losip.
serial number 20, page 31.
Sado Tangu, Losip, yes. Serial number 20,
4,000.
Losip.
20.
Serial number 20.
Page 31.
Yes, Losip.
So you are getting 34,000. Now who is getting more? Where is it? Assistant Section Officer of the State Civil Secretariat.
Yes, Losip.
You say that your post is equivalent to that post.
Yes, Losip.
Okay, let us issue notice. Let's issue notice making it returnable on 5th of June 2025. Means so and so appears on behalf of the respondent number 1, 2, 3, 4, 5. 1 to 5. Mr. Mukher Patin, the Standing Counsel of the Guwahati High Court, assisted by, what is your name?
Mukbang Pertin.
And so appears on behalf of the respondent number 6. All the respondents are duly represented. As all the respondents are duly represented, extra copies of the petition be served upon them by tomorrow. Early date to be. The case of the petitioner herein is that the petitioner is a record keeper in the registry of the Guwahati High Court, Itanagar Permanent Bench. And his basic pay is 35,000.
Yes, Losip. Level 2,
35,000
Losip.
as per the order dated 1/7/2024 issued by the Register, Guwahati High Court, Itanagar Bench. It is the case of the petitioner that the petitioner's post is equivalent to the post of Assistant Section Officer in the AP Secretariat, Itanagar. And as such, the petitioner is entitled to the scale of pay of PB2, rupees 9,300 dash 34,800 plus 4,200 GP per month. What is the present one? Mr. Counsel?
Yes,
This is
Lordship.
an old one you are giving. Whereas the petitioner has been appointed, petitioner's salary is in PB1, rupees 5,200, less 20,200 plus 1,900. The petitioner therefore seeks for an appropriate read, direction and order in that regard. The learned counsel appearing on behalf of the respondent number 1 to 5, as well as the respondent number 6, shall bring on the respondents number 1 to 5 as well as the respondent number 6 are directed to bring on record their stand by filing their affidavit on or before 2nd of June 2025.
Obliged, Lordship.
Item number 2 and connected item 24 of the daily list.
May I, Lordship?
Yes. You are there?
I'm
For
the-
whom?
I'm for the respondents.
Then why you are here?
I'm
Regulation.
Yes, who is appearing? Where is Mr. Panging?
Lordship, I'm appearing on behalf of Mr. Panging, Lordship.
Oh, fantastic. Tell me.
Yes, Lordship, here, Lordship, the petitioner is agreed for not allowing her to participate in the selection process for promotion to the post of assistant registrar, Lordship. Here, the
And where is the
petitioner,
counsel for the petitioner gone here? Nobody is appearing. And did you file the affidavit or you have filed the affidavit? No?
They are supposed to file the owners of them.
Yeah.
Yes, Arunachal. Mr. Mukpatin, have you filed the affidavit?
Joint affidavit file. Joint affidavit. Joint affidavit. Joint affidavit. It has already been filed from the principal seat.
No, that is only for, but it's okay. They don't need to file it.
Regarding the vacancy list, total strength. AOJ and
No, no, the issue involved was this. 7-4. You want that this court should harmoniously do it. Now, the problem which appears out there is the manner in which the rule 7-4 have been brought in. Rule 7-4 has two facets. The first would be those who are from the administrative officer, AOJ, they can be brought in and be made court officer. So they are in and some who are senior judicial assistant, they are promoted to the post of court officer. Because obviously it's a higher scale of pay.
This is what I was trying to bring up with my, I appear for the private respondents in the item number 24. The appointment to the post of court officer is not a promotion. It is an optional post which can be opted for both by the AOJ and the SJ. If lordship has the,
Is it on deputation?
it's almost in the form of a deputation because
Can there be a deputation to a
because
higher
what
rank?
was- whether it was correctly done or not correctly.
I'm not
done,
on that correctly. We have to
But-
construe it to be correctly done.
it was just, I'll try to explain how I understood it.
Grass
Disciplinary
down.
item number 24, applied under an advertisement of 4/1/2016, which was not placed before this court. I have got it on record. That advertisement itself says that on your appointment as a court officer, you will retain your seniority per 7/4 as SJ.
Very well.
So that was not brought before this honorable.
No, it's
It
okay.
brought in 4/2/2016, which was a subsequent advertisement where which that clause also contained, that clause was contained. He joined that post. Now, if we see the appointment letters of AOJ, any appointment letter of any AOJ, it says you are promoted and appointed as AOJ. But the appointment letter of the petitioner himself says you are appointed as a court officer on reversion of the court officer to the post of S. The person who was then putting the post of court officer was reverted to the post of SJ, which the petitioner was on. Equivalent post.
Show me that.
Yes. Lordship will have that appointment. Yes, Lordship will find it at page 145.
Which one?
45, the repetition number 2755. In exercise of powers conferred under so-and-so, read with rule so-and-so, amended by notification 24/7/15, Honorable Chief Justice please to appoint Lordship will temporarily and until further orders as court officer in the principal seat with date page so-and-so.
Where is the appointment letter? Page?
Page 145 is what I find in my. Otherwise, it will be running page 25 of my affidavit in opposition filed by the respondents. Four to 18. Per month plus other allowances with effect on date of his joining, Vice Dilip Kumar Borua, court officer, reverted back to his original post of senior judicial assistant. So the impression that it is a promotion to the post of court officer is itself wrong. The next page, Lordship will find.
No, whether this order saying that somebody is reverted makes his post non-promotional.
Yes,
No.
because Lordship will find on the, just one page prior to that, my lord. Not one page prior to that. Yes, Lordship will find at page 23. When it is a promotion, how the order reads at page 23.
How these people write the order, that is not the lookout.
The thing is, this, what I was.
We are
trying
not
to impress-
concerned with
what I-
how they do it.
What I was trying
It
to
is a
impress
Mr. This is a promotional post for the post of an SJA. There is no quarrel with that proposition.
that is what. it's
It
not
is a promotional post. The High Court reverts it back to these people out there,
What I was trying to.
deprives their right, does everything. That is different
is
thing.
not a
But
promotional
that does not alter the fact that it is a promotional post.
It is not
Then
a
how do you give him an high scale of pay?
the scale of pay may be higher because the work nature is different, but it is not a higher post as
But
such.
are you saying that an AOJ would be demoted?
No.
Then
AOJ
it is
can
not a
opt-
deputation post.
the AOJ can opt to become a courtmaster for some time.
Court
And
officer.
it's an option. A
Court
court officer, I'm
officer.
sorry, not court.
Don't make
the
it
wrong term.
court master.
Court-
He
court
comes
officer,
to number 3.
Yes, sorry.
Yes.
What I was trying to impress is both AOJs and SJs can opt to become court officers temporarily. With the qualification that they would go back, they can be reverted back and their seniorities will be maintained in their individual grades.
Where is it that they can be reverted back? As
The
per the
very
rules.
order, it's the
No, forget about these rules, orders. Orders does not make the rules. We are deciding on rule 7.4. Does 7.4 says about, because court officer's appointment is not given anywhere except 7.4. Okay. Now the feeder category of court officer can be seen from two. One is AOJ as well as from SJ. These are the two feeder categories. Okay. Now, once a person becomes a DR, it does not say that it can be reverted back. It doesn't say. The rule 7.4 is silent on this. Somebody has put that order, somebody has been done to that effect is the wrong. I'm not going to interpret a rule on the basis of an order being passed by the Registrar General.
Next order, which is appointing as a court officer, it says if you are appointed as a court officer, it's always an appointment in addition to what he was as an SGA, he can opt to be also, he can opt to go and become a court officer for some time. It is on the next page, 146, Lordship will find this.
No, then in that case, you could not have brought that officer of the court officer within class 2C.
Class 2C bringing is only because of the higher pay grade, not because of the higher hierarchy. It is because that post carries a higher scale was given to that post. It is an optional post.
Then
I
why
can
do you
opt to
make
go
it
to the post. I may not opt to go to the post.
No,
In a
it is
promotion.
not an optional post.
In a promotion.
You don't have you have only two feeder categories. One is AOJ, who may go for an equivalence to that. It is of an equivalent post.
The pay scale is different, but the work culture is totally different. So
The
I make
different
so one
The
AOJ
grade
needs to
pay
go.
is also the same.
The AOG who wants to go is only changing his work culture. SGA who wants to go gets a higher pay and a work culture. But it is not a promotional post because
But
otherwise
how do you revert him?
then there will be no then the AOG cannot be a feeder cadre because it is the same thing. The same pay scale, the same everything, the same class. How is it a promotion for the AOG then?
It is not for promotion. He has opted.
Therefore, the SGA has
For AOJ, he has opted. But SJ, it is a promotion.
the advertisement is opted. The advertisement says you may give your option, not for promotion.
We are not going for, on the basis of an advertisement, we are not going to interpret Rule 7.4. Mr. Mudumdar, kindly appreciate, whatever may be, I am not going to interpret 7.4 on the basis of an advertisement or the understanding of this officer's concern, how to write an appointment or a notification or whatever. No,
Go to
nothing.
7.4. It is an optional post.
It's not an optional post. The moment it is a feeder post. These are the two feeder categories.
AOG,
It is a different thing that the rule has been made horrendously. It is another aspect. I'm not on that. But the fact that it is a rule by which 7.4 categorically says that the AOJ can become also is a feeder category to a court officer as well as an SJ. That's all. It does not say that there can be a reversion.
the understanding of the rule, my lord. The understanding of the rule, the understanding of the post.
But can you tell me, can there be a case of a reversion? Unless the rule permits. Once a person who is a court officer.
Therefore, a reversion can only be on the
No, can there be a
penalty?
No. Yes,
In
that is
normal
what
service
we
rules. But when a man opts for a particular post, like a deputation,
This is not a deputation. This can't be a deputation post. This cannot be a deputation post.
When equivalents go there and also their juniors are allowed to opt for it. When it becomes an optional post, therefore I was not using the term deputation. Within the same department and all, I'm not going to use the word deputation. But when an equivalent person or a below person can opt to work on a certain post for a limited period of
If it is an ex-cadre post, I would have understood. There might be earlier the court officer was an ex-cadre post.
yes.
Then one could
It
have very
was-
well understood.
It was
But once it is not an ex-cadre post, it is a cadet post, then obviously and goes to a person who the 2C goes out there. 2B, 2C. 2BB goes out there to become 2C or 2CA, which is a non-gazetted post, becomes a gazetted post officer out there. Notion of reversion being made has no relevance.
was earlier just which I referred to was that there was
Rule has been made in such a manner, but that doesn't mean
Here's the
that I'm.
case a court officer post becomes vacant either when that man as an SG gets a promotion to the AOJ, he leaves out the court officer post. Otherwise, once the SG becomes a court officer on option. he
No, no,
proceeds
no,
all
first
the-
of all, no, if we are, let us assume. Let us assume that it is whatever may be. But he has a right to be considered in terms of 7.3.
on his seniority as in the, yes,
Maybe,
He was
but,
an
but no, not, forget about seniority. His seniority will be taken as SDA,
yes.
but he has a right to be considered.
I think consider is never was never the issue even in
So
this.
that is the issue.
In this petitioner's case, what had happened is, in this petitioner's case, what had happened is,
In this
further
case, the
seniority
petitioner's
was left
case,
out.
oh, Mr. Mojumdar, the petitioner's case out here is to the effect that this person concerned, he has been said that you cannot come, you cannot be considered. You cannot be considered or brought within the consideration.
That is Itanagar matter. I am on the Guwahati matter. Guwahati matter is actually a little bit different. What happened in the Guwahati matter is, he is holding the post of court officer. He said that I am not being considered for the post of esteem registrar. Now, he was not being considered because there were persons senior AOGs or AGs above him. And he in his petition says that the advertisement never said that my seniority will be counted dead, number one. Number two, all these years I was kept out of the frame. That is his case with both the posts, because both the cases relate to one issue. The court officer
On the
wants-
ground of seniority,
Otherwise,
on the ground of seniority, you may not bring it.
yes,
On the basis that you will have within for one post, you may have only 5. Is
yes,
the regulation, you may only consider this
yes.
5. These are different aspects.
Therefore, may I-
But the fact that you can, if he comes, being a post, being a office court officer who comes on the 2 seat,
yes,
he would definitely have a right to be considered for the post of the assistant registrar, subject to having, coming within the zone of consideration.
therefore, my lord, the case of Arunachal Pradesh and this Guwahati Nagar case perhaps differ and need not be taken up in one consideration. Let them stay together. But the Arunachal, because Arunachal case, what I understand is a little bit different. They are not, they are denying him because you are a simply court officer. That it is being denied to him because he is simply a court officer and you are not anywhere. It's the issue.
No, no,
That
this
is not the
no,
issue.
this is the thought process of the Guwahati High Court.
Yes,
Therefore, you have to you see, it is the same High Court, the Guwahati High Court, who have done for both. That thought process is, being a court officer, you cannot come within the zone of consideration for the post of esteem minister.
seniority allows him to come in. Once the seniority allows, he has to come in his work.
Therefore, whether he will become within the zone of consideration is another aspect, for which his seniority will be taken into consideration for that purpose, under XJ or AOJ, whatever may be.
Yes.
In fact, the problem which happens with Rule 7.4, which I understand, is that you keep the AOJ in the in seniority with the AOJ. But the AOJ seniority should also be taken from AJ. Then in that regard, the thing would have been much proper.
Yes.
The problem with AOJ is being kept with the seniority of AOJ, but if it was done with AOJ and is being taken with HJ seniority, obviously the persons who you are representing would obviously have a much ahead, taking into account they were much senior.
Yes. Now,
Because this person came in out here only in 2016 or 17 as an SGA. Whereas some of the persons have come in 2008-9. So they have been deprived of there. Now they have become a AOJ.
how do he become AOJ? He remains below them in the HCL post. Although he becomes a court officer, even if we try to take him to equivalence of an AOJ, he will remain down below because he was already junior class. He cannot still a master.
Now, another problem is that from a court officer, he cannot be an AOJ.
AOJ.
Because there is
He
not a
promoted.
feeder cadre.
He has to be promoted to the post of AOJ from court officer, not from court officer, but from SG. He will be promoted to AOJ from as an SG.
From any AOJ. Now
So
the
therefore,
problem-
when he is a court officer, his seniority is maintained at SJ so that he gets a chance to become the AOJ for the direct promotion part.
So therefore, the Rule 7.4 creates that problem. Without properly analyzing that thing, that problem, because what will happen otherwise? The question of reversion does not arise. They may have put all these lines out there, whether raise the general out there. That is a different thing. Appointing authority may put out there, but that is not in conformity with the rules. You cannot revert somebody unless the rule permits.
So that reversion may happen for him or not. Once there's a step for reversion, that question would come in whether he can be reverted or not. As of today in the Guwahati High Court case, the issue was, a clause was inserted that my seniority will be maintained as an SJA, though I am a court officer. That was not announced in the advertisement. That I did not know when I applied for it. And therefore, my seniority I should be allowed to now contest for the post of assistant registrar over and above those AOJs who are senior to me, and also over and above those SAJs who were senior to me. So that is a totally different aspect this petition is on. Although the issue is of whether from the post of court officer one can be considered or not. When the petitioner needs to be considered, it will not be considered for the post of assistant registrar from the post of court officer. He will be
From the post
considered,
of court officer, he can be taken to the assistant register.
yes, can be taken there direct, but it will not be directly as a court
But
officer
his
becoming a
seniority will be taken from SJ.
from SJ, AOJ, wherever he was, that seniority will count when
But
he
the problem arises is, in SJA, he may be a senior. But how do you intermingle the seniority with AOJ with SJ?
Therefore, when he maintains it with the SJ, the seniority is maintained with SJ, his next promotion would be AOJ.
That is okay, but
So from
But the-
AOJ, he
but-
becomes an
but-
assistant registrar.
but the moment court officer has been brought within 2C,
Yes.
he becomes a feeder category or feeder catered to the post of assistant register.
That
There's
is
no
not
point.
there in the rules. That is not there in the rules.
That is there,
That is
7-3.
there, that is there.
That is the problem which
This is
is
the
happening.
crux. This is the
Rule
crux.
7-3. Problem arises because of that.
One single sentence, if I
But
can.
from 2C, it says from 2C.
2C,
2C.
is there.
So
Court
therefore-
officer. Court officer is 2C.
Court officer is to see.
So if he is now considered in 2C, to be someone in 2C, and therefore he gets consideration there, then his seniority has to be counted where?
That is the problem.
That is
That
the
is why
problem.
I am
Therefore,
asking
the
you,
appointment
how
letter-
do you intermingle both?
So therefore, the appointment letter says that your
No,
seniority.
no,
will be
appointment,
declared
forget
as
about the
a-
appointment
And
letter.
7-4 clarifies that.
Appointment letter cannot go beyond the rules.
That is what 7-4 clarifies.
7-4 does not say so. 7-4, what does it say? 7-4 says that for the feeder category to the post of court officer, there would be either from the AOJ, whose seniority will be taken from the AOJ. And those who is in the court officer from SGA, his seniority will be taken from SGA. This is 7-4.
Well, this notification, well, page 65 notification is under challenge before it is.
Okay.
Because there is already a 7-4 in the book.
The persons appointed as court officers shall maintain their respective seniority in the original cadre of administrative officer and
Or.
cadre of administrative officer, judicial or judicial assistant, and their further promotion will be considered on that. So, to come in as a court officer, it is not the seniority it is being talked of. Once he is appointed as a senior court officer, then also his seniority is maintained. There is
That is indicated.
That is what I'm saying. The problem with this rule is this.
Yeah.
How do you, what you call, put both these rules, both the categories together for the purpose of 7-3? Seniority, how do you look into it? Because for AOJ, because whatever may be, they may write many things as reversion and all these things. This is administrative. But judicially, one has to look into it. And if you see rule 7-4, it categorically says that these are the two feeder categories. One, it goes parallel. There's no promotion. Somebody may, okay, I hope to become a court officer. But the other, he gets a not one, two, three higher grades of pay. Because in between the HGA, you have the assistant protocol officer, then you have the court officer, court master, and then above that, court officer. So he even surpasses to BD and directly goes to 2C.
Once he reaches there, he maintains his seniority in SG.
HGA.
So therefore, when the promotion to the court officer, to the post of assistant registrar will be considered, his seniority will be considered as was his seniority in the SGA, and AOJ's seniority will be considered as they were in the AOJ's. People who were senior to him as SJs become AOJs, so he cannot override their seniority. He remains below them. So his chance of consideration will come once people over him in the AOJ are done, have been considered, promoted, rejected. Once they are done, therefore, that intermingling which I am trying to understand is that he may be a court officer, he will get a chance to be considered, but he will get a chance to be considered once people in the AOJ posts have been considered above him. Their cases gone, he comes in when the AOJs are being considered. Or court officers who held the post of AOJ who are holding
That I understand. There is no problem with that. The problem which arises is, just for example, a person, he is in the court officer. He's still court officer. He remains court officer for another 4-5 years. In the meantime, some junior of him becomes an AOJ. Because we have to think in that line.
Yes, yes.
Junior in an SGA cadre becomes a court of AOJ. Then what happens?
Before considering that particular SGA for AOJ, he has to be considered for the post of AOJ. Suppose he gets promoted to the post of AOJ and he continues to hold the post of court master, he is an AOJ who has opted to remain a court master. Therefore, he will maintain his seniority above this SG.
Above this,
Even in the post of AOJ, he will continue to remain his, continue to hold his seniority over the person immediately below him on the SG.
so you mean to say that the AOJ, who is otherwise senior to him in the HA,
Yes, yes.
could be considered come within the zone of consideration.
Yes.
He
His chance
in the HA cadre,
comes and
he in the HA cadre has the seniority to be considered.
yes. Otherwise, what happens is if he remains a postmaster, court officer, and an SGA below him becomes an AOJ, he has actually lost a promotion. That cannot be allowed. So while that is what happens in central government when they are sent on deputation. Even if a man is in deputation somewhere, when his juniors are being considered for promotion, this man is also considered. Even a notional promotion, but he remains there. When he comes back, he regains his seniority immediately over his juniors. There's no difficulty on that. The next time promotion comes, they all go by a lot. That is what is required to happen now by this Guwahati High Court petition. What has been sought to be done and what has actually been done by the interim order is AOJs who were supposed to be who were not in the zone of consideration because of their seniority, they were left out. He being a court master, court officer who was still to become an AOJ at any point of time, he got a chance to sit in the interview, leaving out these persons, not once, twice. So that, if that is allowed, then any person who opts from a lower rank to become a court officer, he will always feel a march over.
What is the consideration? What is the criteria for promotion? Is that?
The assistant registrar lordship, where it comes seniority, that seniority has to
If
come
it is
in a
merit cum seniority, then how do you take into account only the 5 seniors? Or how do you take note of? If it is the merit cum seniority, then how do you have the zone of consideration?
that zone of consideration in my affidavit I had given, my lord. That notification. Then fine. Yes, at page 147 is one notification.
1:5.
147.
Affidavit 9%. So it is 1:5.
And then there is another notification at page 149.
So it is 1:5.
So it
So
comes,
if he comes within the 1:5,
then you would have an option to go and sit in that interval. This not being placed at the initial stages to interim orders, otherwise you would miss out. Assuming that the requisition have succeeded, you would have missed out that interview. So he was allowed in the interim to appear. That perhaps was, in my humble submission, was not required to be done.
so in fact,
Proper
that,
facts.
that is the only problem.
SJ, he
how
will
do
be
you-
counted for his promotion to the post of AJ first, although he remains a court officer. In his seniority turn as an SJ, he will be considered to the post of AOJ. In case he gets it, then he will be an AOJ who is serving as a court officer. The moment he falls within that merit, seniority, that consideration.
No, we cannot make that. We have to read down the rule to say that 7th floor, although it is taken for the purpose of AOJ, but interested seniority of the AOJ would be with the HJ. Somewhere that link has to be.
That link has to be made. That link is missing. To be made so that persons who were earlier senior should not miss out their opportunity of sitting there. Persons who were junior should not steal a march over because they made an option to an optional post which I could
But
have.
this is not an option.
Let us see it be a promotion, but if he, because just because he has
But
gone
the
there,
fact that Rule 7(4) categorically mentions that his seniority will be maintained from SA. He has a right to be considered in the post of examination, but taking into account his seniority is from SJ, it cannot steal the march over the AOJ who have been appointed to seniority. Now, but how do you take care of a person who, because this is merit cum seniority,
yes,
how do you take care of the situation that a senior person who is there appointed a person senior to him may not be appointed to the year because his merit cum seniority. Then what happens?
then he, when he steals the march over that person to become senior in the AOJ list, this man remains where he was because he has become as AOJ. He will not be counted in the SG. When he supersedes this man because of his merit, the other person remains in the SG, he becomes an AOJ. So he will
But
remain
he,
in the
he
seniority
doesn't,
for the AOJ.
but he cannot become an AOJ. So for the AOJ code officer is not the feeder category.
He becomes an AOJ because he was also the SJ. His seniority is maintained at the SG.
And if we say that
SG.
the code officer is equivalent to the AOJ, then the problem again arises.
Then again it will break down because once he becomes an court officer, he will have to leave everything in the SJ. Now he is no longer in the SJ cadre for any purpose altogether. If we take him up totally, so therefore what has been done perhaps is that you go and you hold that post like a deputy minister, like a deputationist, like what I'm saying is like a promoted deputationist. Let us have it like a promoted.
No, property,
But-
it's a promotion.
But he cannot be allowed to steal a march over to other AOJs because with the AOJ he cannot have a seniority. It's an equivalent post, not in the cadre of the AOJ, so he cannot be brought into the AOJ. He has to be kept somewhere. How to be kept? You do everything you have to do as a court officer. You maintain your seniority in the SG. Once you become the AOJ, your holding of the post of court officer is in equivalence with an AOJ now, not as an SG. You are no longer an SJ holding the post of a court officer. You are an AOJ holding the post of court officer. Therefore, you come over to the AOJ. Now, any person who was senior to you as an SJ and missed out his promotion becomes junior to him.
Now, let us see, means how do you make the zone of consideration is on the basis of seniority?
Yes, from the top.
Where
Next
is
slide.
it mentioned? Let us see. The number of incumbents in the zone for promotion in the next higher cadre is 5. Then how this 5 will be done? Why do you say that it will be the senior fives?
That notification perhaps will be one older to this because this was a modification of earlier 2011 notification, which I do not have in mind. Whole administrative, as I have understood, it is the senior most where it is cut off and then the merit is taken into account because we have 5 persons competing for 1 post, 8 persons competing for 2 posts. Therefore, the gradation list and the seniority list where we cut off the zone of consideration. If merit is to be seen first, then everybody in the zone of consideration is seen. So the zone of consideration, perhaps on the basis of the gradation list of the seniority list, otherwise can assess the merit first and then go for seniority. First assess that this is the zone of consideration before we go into the merit part. These are the persons we'll consider. Now whoever has the merit higher will go. If it is merit come seniority, if it is seniority come merit, then whoever has the requisite merit and is a senior person goes in. Cutoff has to be done for reduction this.
But how do we read that it will be the first 5 senior?
Otherwise, my lord, the first 5 senior, if we try to take something from below, then there should be criteria why we are picking out senior persons and taking in junior persons into consideration.
See, the service rule of the government, because the High Court is not so good. Now you see, just for example, the Assam Stenographer Service Rules. I'm just saying, giving. The appointing authority shall then furnish to the board the following documents and information with regard to as many officers as equal to 4 times the number of vacancies in order of seniority as are eligible. Now, where is that in this particular notification?
I may require little time to go through all the matter, but I'll note down the issues and I'll come back. Because the seniority has to be the criteria. The first.
No, unless
first
it is
few-
being given. Because everywhere it is being given. If I remember the engineering rules also merit cum seniority. Isn't it, Mr. Chaudhary? So there is always mentioned that it is from the seniority, on the 4 times the year on the basis of seniority. Now, if it is not there, then how do you say that it is only these first 5 senior people is to be taken? We'll hear you again next Thursday. Come back on that. Or is it an universal proposition? I think this has some problem with this notification. They have made it in this manner, just made it without saying that it will be from the seniority.
Not made by legislature.
This is the
with
problem.
the actual proper background to think about what will be the implications of
Yes.
deliberation. And therefore, whatever came to mind was perhaps put in.
Yeah.
The responsibility now lies with.
Therefore, how do you say which 5?
Yes. Now I'll try to find out proposition of law that if it is not given, there's to be further gradation list of senior persons, or whether there's anything in these rules anywhere which will say that the zone of consideration will be on the basis of seniority and then the other parameters. That is what I would.
And if it is not, how do you take it? This notification becomes useless. Because this is for maritime seniority.
Yes.
If you don't say for five, for one post, vacancy five,
Five
the
persons
zone of
have to come.
consideration.
Five senior.
Five, if it is not senior,
Uh,
you can't bring in five. Then you brings this notification cannot be
then,
relied upon.
then only merit will be first seen, then 49, whoever is meritorious, everybody loses their seniority, the deduction becomes done then. For no reason. I'll try to find out that part of the law. I'll come back on.
You also,
Yes, Mullah.
I have been arguing on your behalf.
I'm
You are not saying any a single word.
I'm so obliged.
Mr. Mukpatin will hear again on next Thursday.
Yes.
First of May.
The matter.
Next third is first of May.
Matter having been. Matter requires further deliberation for which the matter is again fit first of May 2025, 2 p.m.
2 p.m.
Obliged, madam.
Item 3,
Lordship, I'm appearing for respondent number 1, Your Lordship. I need some time to file my affidavit, Your Lordship. I've received the instruction.
You are paying for whom?
For 1, Your Lordship.
Government.
Yes,
Why? Why do you have to file?
for secretary law, Your Lordship.
Where is the government file?
Yeah, I have to, 1 week time, I have to, I had seen the instruction. And I got- Next, I will also fix it on my next,
50,
next, Thursday.
50,000?
So my lord, I have received what happened, my register and register.
No, does it take such a long time for you to file?
No, my.
You are the person who have caused all the problems. You are the person who have caused all the problems.
Exactly, my lord. Actually, my register vigilance.
If you have not raised that issue, then the respondent, the petitioner would have been happy working with the respondent number 5,
File not even,
50.
file.
Register vigilance, my lord, reason, very plan, my lord, because I got explain, my lord.
Is the High Court not working without the raised vigilance? Huh?
He's the only party, my lord, here.
So if he's not there, the joint the register vigilance will do it. Who is the register vigilance?
But two.
There's a new register vigilance. New one.
Trying, my lord, pass. Only one. I will buy 3 days, 2 days, my lord, February, my lord.
You file your affidavit. And government, you
Yes.
filed the affidavit as to why you have not given the clearance till now. Because the Arunachal Pradesh Human Rights Commission says that they are not in a position to release the petitioner in view of the government of Arunachal Pradesh not doing it. File your affidavit.
Lordship,
Okay.
Lordship.
And madam, if you don't file an affidavit, we will see the presence of the Judicial Department, the LR, in Guwahati. Weather of Guwahati is very good. Okay. It is seen that the affidavit have not been filed by the Guwahati High Court in spite of the specific direction being given by this court by an order dated 4/4/2025. Further to that, it is also seen that the register number, what is that? Respondent number? The respondent number 2 have also received the copy of the petition as far back as on 27/3/2025. Full stop. Apart, this court further takes note of the fact that in the affidavit filed by the respondent number 5, there is a specific mention that the respondent number 5 is not in a position to release the petitioner without the approval of the state of Assam, a state of Arunachal Pradesh. Full stop. The secretary of the judicial department of the government of Arunachal Pradesh, oblique, the legal LR, shall ensure that an affidavit is filed as to why no permission has been granted to the respondent number 5. List the matter again on 15th of May.
Can it be only on 16?
16 not possible. These 70 matters, High Court matters, 17th, you come to the court on a Saturday.
Before 15?
You're going somewhere. Okay, on 22nd of May. On 22nd of May 2025, the affidavits be filed without fail by 16th of May 2025. On by 14th of May 2025, the petitioner, if so aggrieved, if so advised, would be at liberty to file their reply on or before the next.
Item 5. Well, sit item 5.
Yes, Mr. Sharma, where are you? Where you are now appearing? Yes, Mr. Boysa, you are collecting still?
My lord, what happened, madam? Ajay has submitted. He requested. Kindly come to my affidavit, my lord. 100 page, 100.
Are you saying that the petitioner requests and you deduct
Till
March?
25th.
My
They are also
goodness.
holding.
No. Who is that? Your DPO? District judge who?
Now he has been transferred to
Who was that DPO?
Kamlong, my lord.
Who is the district judge? He should be taught a lesson that doesn't know anything about law or not. Who is your district judge?
At that point, Bojali, my lord, district judge Bojali. Now he is in Kamruk rural. As per my.
No. Who is now the district judge? Then I think you should be. They are not responsible. In spite of there being anything out there, you pay. You dispose it of. Pay that along with
My lord,
compensation.
Only the.
No, this is a
amount
High
by the-
Court. High Court at its worst. We say about the Guwahati High Court knows the law. The officers, the subordinate judiciary has gone to dogs. In one case, merit come seniority, seniority come merit, they have no idea. These are judicial officers. Huh? Or do they only know the CPC? Which I also doubt, taking up bench work. No, we cannot burden the state because of what we have. The interest should be paid from that earning officer from the month of 2023. 2023, that letter, the interest which is to be paid from that officer, from his salary. This is the way how things will go.
From 23 to March.
The interest which is to be paid has to be deducted from his salary and then paid to him. Okay, deduct it from his salary, from the district judge, whoever it is. And the remaining, you pay.
My lord, before that, my lord, kindly, pay this,
No, nothing. Nothing doing. What you have done is,
he has, furnished the certified copy, my lord, and he has requested, my lord.
is there a stay?
No one.
Then why have you done it? Now therefore, pay the salary. This should be deducted from all the officers who were responsible from them. And being the district judge who was the responsible, you deduct it from his side. This is not right. The whole-
My lord, prior to 20.
No, Mr. Sharma, enough. Your matter, I don't want to discuss much on the your level.
My lord, prior to 20.
Not nothing doing. Remaining is a cost. This type of litigation is because of a cost upon Mr. G. Bush. 50,000. It is a goodness.
My lord,
Lahok heard
They-
Mr.
they are
K.
doing
Sharma. No, nothing doing. 50,000 upon you.
no, my lord.
You pay whatever you don't pay, then we know how to do it. We'll ask the district collector to recover it as land revenue from you. Heard
Everything
Mr.
is-
K. Sharma, the learned counsel appearing on behalf of the petitioner. Gustav, Mr. Government. Mr. T.R. Pukon, T.R. Gogoi appears on behalf of the respondent number one. Mr. G. Busher, the learned standing counsel of the Guwahati High Court, appears on behalf of the respondent number 2 and 3. Mr. R. Borpujari, the learned standing counsel, appears on behalf of the Finance Department. And Mr. R. K. Talukdar, the learned standing counsel of the Accountant General A.E. Assam for the respondent number 5. The present writ petition has been filed by the petitioner seeking a direction upon the respondent number 3 to 5 to withdraw the communication dated annexure 8 and 9 communications enclosed as annexure 8 and 9 to the writ petition and find it and further direct and further to quash annexure the said communications enclosed as annexure 9 to the writ petition. Full stop. Taking into account full stop. The brief facts which led to the filing of the instant writ petition are narrated infra. That only. Mr. Barbuzari, I don't think I should say anything about what has happened earlier much.
It opens some Pandora's box.
I'll have a little fun. The petitioner herein was brought within the services of the state of Assam now was appointed as an office boy in the office of the district and session judge Borpeta, thereby bringing him within the ambit of employment under the state of Assam by an order dated 12/2005. The record reveals that the petitioner thereupon have been promoted and transferred have been promoted as well as transferred. And at present, the petitioner is functioning as an LD assistant. LD assistant. In the where? In the establishment of the district and session judge Bozali Patsala. The dispute involved in the instant proceedings pertains to a direction issued by the senior accounts officer pertains to a communication issued by the senior accounts officer of the respondent number 5 to the district and session judge Bozali, dated 16/11/2023, wherein it has been informed that those persons who have joined the government service on or after 1/2/2005, they would not be eligible to join the General Provident Fund, and any amount collected on account of General Provident Fund would be refunded to those persons with interest. However, after 31/12/2011, there shall be no interest admissible. On the basis of the said letter, the district and session judge Bozali, who is the respondent number we have not made him a party also, na?
Not a party, rather I feel why not the chief administrative officer.
We have not made him a party also because of the fact, because he is the appointing authority. District and session judge Bozali had written a communication, had issued an order on 13/12/2023 asking the petitioner to submit the final withdrawal application form of GPF for drawal of GPF accumulated contribution as sought for within 30 days from the receipt of the said order. The petitioner have assailed the communications dated 16/11/2023, bracket annexure 8, as well as the order dated 13th of December 2023, bracket annexure 9. On the ground that the petitioner is entitled to subscribe to the General Provident Fund, having been initially appointed in the year 1998. On temporary basis. And it is under such circumstances the present petition has been filed. What is the name of the case? The judgment I've delivered, what is the name?
WPC 6403 of 2020. Lordship has delivered judgment on 31/3/2023.
From the materials on report, it is seen. That this court have duly perused the materials on record. Wherein it is seen that the petitioner, though was appointed by certain orders being passed by though were appointed by the district and session judge Kamrup on 21/1998, as well as subsequently but all these appointments were absolutely on temporary basis, on fixed wages.
Personal in nature, yes, but where appointment engagement itself appears to be personal in nature. Because where he was moving.
It further appears that those appointments were personal. Not personal, it can't be personal, it would be
And he was transferred to a district judge. He has carried along with him the bid petitioner. And his appointment came to be in the first station of posting.
and the said appointment of the petitioner appears to be more personal to the district judge who had appointed the petitioner. In as much as wherever the concerned district judge approach was transferred, the petitioner went along with him. It is, however, seen that by an order dated 1/12/2005, the petitioner was again appointed purely on temporary basis as an office peon in the office of the district and session judge Borpeta by the then district judge Borpeta against a vacant post. The legality or the illegality of the order by which the petitioner was appointed on 1/12/2025 is not an issue. 2005 is not an issue. But from the materials on record, it is seen that the district and session judge, Bozali, have written communications to the respondent number 5 that the petitioner was appointed substantively on 1/12/2005. This court would leave this aspect, would not further like to deal, would leave this aspect at that. Now, the question arises that as the petitioner was only substantively appointed on 1/12/2005, can the petitioner, could the petitioner have subscribed to the General Provident Fund? Na? General Provident Fund. It is very pertinent to mention that the General Provident Fund is a fund being created under the premises of the General Provident Fund bracket Assam Service bracket close rules 1937. The said bracket deal hereinafter referred to as the rules of 1937. The said rules of 1937 was amended by the notification dated 14/7/2011 and given retrospective effect from 1/2/2005. The amendment so made was to insert a further proviso to Rule 4 after Proviso 2, stipulating that a government servant appointed on or after 1/2/2005 to the services and posts in connection with the affairs of the state government of Assam, which are born on pensionable establishments, whether temporary or permanent, shall not be eligible to join the fund. The said notification being relevant is reproduced here in under judgment 2023 SCC 2023 SCC online GAU 1165 paragraph 9 of the notification concept. This notification, this amendment to the rules of 1937, however, is not put to challenge in the instant proceedings. Considering the scope and ambit of the said notification, said amendment, whereby the third proviso was brought to Rule 4 of the rules of 1937. No government servant appointed on or after 1/2/2005 to the services and posts in connection with the affairs of the state of government of Assam, whether temporary or permanent, shall be eligible to join the fund. Accordingly, the petitioner having been appointed only on 1/12/2005 could not have joined the fund. This court further takes notice that immediately upon issuance of the said, after this, immediately upon the amendment made to the rules of 1937 by the notification dated which was notified on 14/7/2011, a communication was issued by the Director Finance Budget Department to all the administrative departments, all the heads department, informing about this amendment and further directing that the contributions so made till the issuance of the said communication to the General Provident Fund be refunded with interest up to the month preceding the month of issue of authorization of the Accountant General Assam within 31st of December 2011. It was also mentioned that there shall be no claim for interest on GPF accumulated. Accumulated, what is that? The word?
Then if beyond 31,
Beyond is okay. Prior to that? Stated. Beyond 31/12/2011. First. Under such circumstances, this notification, under such circumstances, in view of this communication, all departments of the government of Assam, including the judicial department of the government of Assam, were informed that no person would subscribe to the GPF who were appointed after 1/2/2005, and further, any amount which was retained, which was collected from those state government servants who were appointed post 1/2/2005 were to be returned refunded within 31/12/2011, and post 31/12/2011 there shall be no interest. Be that as it may, the district and session judge Bozali continued to deduct Bozali, under whose establishment the petitioner was working, continued to deduct the amounts towards subscription of the General Provident Fund from the petitioner, and the same were duly deposited in the treasury. And the respondent number 5 also provided due accounts, the due certificates, due statements, stating inter alia that as regards the said deposits, the petitioner would be entitled to interest at the rate of 7.1% per annum. To The deductions were made by the district and session judge from the petitioner, though at the volition of the petitioner, was unlawful. And the further retention of the said amount by the Accountant General AE and issuing certain statements to that effect that the petitioner would be entitled to interest at the rate of 75.1% per annum was also unlawful. This process continued till a communication was issued by the where is the communication? He has written the letter, no?
Page 46.
The 46 is okay, but where is his communication? 38. 38 communication is where?
Yes, 48.
38.
48.
Here. No. This process continued till the district and session judge Bozali, by the communication dated 30/8/2023, made an inquiry with the respondent number 5 as to whether the petitioner was entitled to subscribe towards the GPF. This document to this said communication, the petitioner, the senior accounts officer had informed the district and session judge by the communication dated 16/11/2023 that there could not have been, that the petitioner could not have subscribed to the GPF, and any amount which accumulated till 31/12/2011 the petitioner would be entitled to interest, and beyond that there shall be no interest. In spite of the said communication dated 16/11/2023, it has been brought to the attention of this court by Mr. G. Busher, the learned standing counsel of the Guwahati High Court, that till March 2025, without there being even any order being passed by this court, the district and session judge, Bozali, continued to deduct the said amount from the petitioner and deposit the same in the treasury. And the respondent number 5 continued to issue statements to that effect. This court, on the above basis, duly heard the learned counsels. It is the opinion of the court that with the amendment being made to the rules of 1937, and there being no challenge to the said amendment, the petitioner herein was not entitled to subscribe to the GPF post 14/7/2011. Full stop. This aspect was also duly informed by the Finance Department of the Government of Assam to all the departments, including the Judicial Department under whom including the Judicial Department of the Government of Assam. However, in spite of that, the District and Session Judge Bozali Patsala, as well as the respondent number 5, continued to accept the contribution made by the petitioner and issue statements to that effect, which is also illegal and unauthorized in law. This court, however, cannot be unmindful of the fact that the petitioner's hard-earned money have also been deducted by the respondent authorities, and certificates have been issued that they would be paying interest at the rate of 7.51%. Additionally, this court finds no justification as to why the District and Session Judge Bozali Patsala continued to permit the petitioner to contribute to the GPF even after 16/11/2020, even after receipt of the said communication dated 16/11/2023. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. Number 1, the petitioner is not entitled to subscribe to the GPF as the petitioner was appointed substantively only after 1/2/2005. Number 2, the petitioner herein the respondent number, the District and Session Judge Bozali, as well as the respondent number 5, would not have accepted, the District and Session Judge Bozali would not have deducted the said amount as contribution from the petitioner. And the respondent number 5 also could not have issued certificate statements that the petitioner would be entitled, would not have retained the said amount and issued statements that the petitioner would be entitled to interest at the rate of 7.1%. However, as the respondent authorities have withheld the amount of the petitioner, and issued certificate to the effect that the petitioner would be entitled to interest at the rate of 7.1%, the respondent number 5 would be bound to pay the interest at the rate of 7.1% till 16/11/2023 to the petitioner, along with, while refunding the amount which have been accumulated in the fund of the petitioner, accumulated. Full stop. The interest would be payable at the rate of 7.1% per annum. Full stop. The said amount be refunded to the account of the petitioner within 3 months, 2 months, within 15 days. You have to refund. The more you keep, more interest you pay. To whom? Department or him, the district judge? The, the respondent number 5 shall refund the said amount along with interest as directed above to the petition, to the district and session judge Bozali Potsala within 1 month from the date of the instant order. Full stop. It is made clear that the interest to be paid by the respondent number 5 would only be up till 16/11/2023. However, the amount which have been retained, all the amount which have been retained would be returned to the, would be transmitted to the district and session judge Bozali. Number two. The district and session judge Bozali shall pay the said amount. Now, you do one thing. You pay the interest till him this much, till today, and deduct that amount of from the period from 13th of December 2023 till date from the salary of the district judge, concerned district judge. Who will be deducting? Huh? The judicial department will deduct it from the salary of the erring judicial officer. Whoever. And so this court further imposes a cost of rupees 50,000 upon Mr. Jibush. And if the said payment is not made within a period of 7 days from today, the same shall be recovered by the district collector as areas of land.
He is now district judge rural Kamrup. He was transferred verified.
When?
At present, he is working there.
No, from the erring judicial. The payment will be made to whom? Who will be the DDO? The amount will be made to him, the DDO.
And when he was transferred to Kamrup rural, that information.
No, no, it will be paid to him. The amount will be paid to the. No, you pay to DDO. DDO will be the district and session judge Kamrup. The amount will accumulate, and that interest, whatever it is from 13/12/2023, shall be till date be recovered from the erring officer, judicial officer, being the district judge, the erring judicial officer, which the judicial department shall do.
Because commissioner secretary R1, that is alert. We can take that one. Commissioner and secretary is R1, alert.
Because he has to pay from his salary.
He is now working at under district Kamrup well. So the amount of it paid to the disposal of the Kamrup, district Kamrup well, you pay to him.
From the judicial officer, don't worry, they should do that. Yes, Mr. Pathak, you tell me,
I've gone through the,
why haven't you gone out there? Go and fight it out before the land acquisition tribunal. What is this you are fighting out
check
here?
my.
This injunction order.
My
cannot
colleague.
stand.
I have
Amount
gone
if
through
there's
it,
a
nothing
dispute
much
out
is-
there, you file a reference out there, you told the reference has been filed. What is this
Yes.
type of litigation?
Nothing survives.
Things are
In
bad.
fact, what happened, may I have one submission. I saw the very lengthy, this injunction order, which is under challenge. The parties
parties before the trial court, had they pointed out your lordship's order, that more particularly paragraph 14 onwards, nothing, the order would have been different. Because meeting or no meeting, it doesn't matter anything. Because basically, at page number 222 of that paper book, the lordship has explained exactly what is the situation. After the land acquisition, land is vested with the government. Then the reference case is also, I am told, are going on, and the next date is in June. Now, actually, that had this been pointed out to the trial court, might be the order they have been holding or no holding doesn't mean any purpose.
In fact, it was not pointed out as it is apparent because there was no amendment filed. These aspects were never brought in. By way of an amendment, that these are the change in circumstances. They still went into all these things and the court passed an order and the court understood my order wrongly. Said that I never said that.
This order, well, in your lordship's order at page 222, nothing is left to be decided. Everything is decided. Now, had this been pointed out, to be very fair enough as an officer of the court, had this been there before the trial court, I don't think holding or not holding would have been an issue for an injunction matter. So, my lord, what I have nothing more but to only to concede this, because he has made an appeal as against that injunction order. After your
Because why I took up the matter today itself, because of there's a reason why. If the amount is being stuck with the government, it is not a small amount, it is something around 150 crores. 150 crores is the amount. If it is not deposited, the state is required to do, the moment there is a reference proceedings as regards apportionment of the amount or the entitlement of the amount, it is for the collector to deposit the reference court. And thereupon the reference court will do the need, whatever it is required. Because till they don't deposit, there will be an interest accruing for the government. For the government.
In the other institution, in lordship directed the government.
State government is not a party, sir. It is suit.
But a page 222, if my recollection is correct, your lordship covered up all the points. I took a look at it. Yesterday, I told my colleague that
12(1)(b) that any person agreed by any regard to the apportionment of the compensation will approach the collector by seeking a reference to the court. We also see that when such an application is filed before the collector has to refer it to the court, and in the instant case, it would be the court of the district judge, Kamrup Metro. It is also seen in terms with subsection 2 of section 12 that by way of legislation, by incorporation, the protection of the land acquisition act has been incorporated. Under such a, if an application is filed expressing disagreement in respect to the approach, then in such case, the collector, that would be the district commissioner, has to act in terms of section 831. However, the same is only to be subject to the dispute being raised by filing an application as per the mandate.
On paragraph 14 onwards at page 222, there is nothing that was there left to be decided. Everything was decided. Now, yesterday I have got an instruction that with the reference application is also.
He said to me last time.
I have advised my learned colleague that nothing remains. I thought yesterday, my lord, it is my fault. When he told me that it is a first step bill, I thought it has to be. Nothing remains to be executed now. I'm sorry, my lord, yesterday I thought for 2-3 days time. Your logic order is page 222. Now, I understand from my learned colleague, this was passed in September. Hearing before the trial court took place in November.
No,
September.
you see paragraph 9 of the impugn order.
Page 229.
Where does he get this aspect, the learned trial court?
I think to understand. Yeah, absolutely. Sometimes at the bar also we fail.
So the money is still with the collector.
I think it is with the government, huh?
Government is yet.
With the collector. Because it will be the district collector. Who will have the money. These state of litigations, the government is happy.
At least in the balance sheet, it is reflected.
Actually, this injunction, it has no meaning at all.
Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. R.J. Das. Hearing on behalf of the commission. Equivalence and a part of the learned senior counsel. Learned counsel appearing the respondents. Is an appeal filed under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedures, challenging the order dated 11/11/2024, passed in Midzi case number 288 of 2024, and rising out of title suit number 47 of 2020, whereby the Court of the Learned Civil Church, Senior Division number 1, Kamrup Metro at Guwahati, hereinafter referred to as the Learned Trial Court, had granted and had passed an order of injunction, thereby prohibiting the opposite parties, the appellants herein, from convening any meeting of the appellant society with respect to the properties described in Schedule A to J, or from proceeding any manner regarding the aforementioned properties until the matter is conclusively adjudicated by the court following a complete trial in title suit number 47 of 2020. This court have heard the learned, have perused the materials on record, including the order passed by this court dated 12/9/2024, passed in WPC number 7457 of 2018. From a perusal of the said order dated from the perusal of the said judgment and order dated 12/9/2024, passed in WPC number 7457 of 2018, it would be seen that the properties upon which the injunction order has been passed, mentioned as in schedule, described in Schedule A to J to the plaintiff, are properties which have already devolved upon the state on the basis of an acquisition proceedings. Under such circumstances, the question of granting an injunction in respect to the said proceedings does not arise. In addition to that, this court have also taken note of the impugned order wherein there is a mention by the learned trial court that this court had distinctly instructed that no compensation shall be disbursed without the prior permission of the court. The said statement, the said observation, and statement made in the impugned order is perverse, inasmuch as the judgment and order dated 12/9/2024, passed in WPC number 7457 of 2018, does not in any manner restrain the disbursement of the compensation. In this regard, this court finds it relevant to take note of certain paragraphs of the judgment and order dated 12/9/2024, more particularly paragraph number 11 to 15, 11 to 15, which are reproduced hereinunder. From a perusal of the above paragraphs, it would be seen that this court have duly taken note of that the land have already been acquired by the state government under the provisions of the Assam Land Requisition and Acquisition Act 1964. And the compensation was been duly quantified at rupees 153,04,12,672. In that regard, the said amount is lying with the state government, oblique the district collector, which is yet to be disbursed. However, on account of the injunction, the said disbursement have also been stalled, which have resulted in loss of interest to both the parties to the instant appeal. In addition to that, this court have been duly informed by Mr. K. P. Pathak, the learned senior counsel appearing on behalf of the respondents who are the plaintiffs, that the plaintiffs have also prepared applications seeking reference under section 12(1)(b) of the Act of 1964. And in pursuant thereto, reference proceedings have been initiated before the District and Session Judge Kamrup Metro at Guwahati. Taking into account the above, nothing further survives in this instance proceedings. Nothing further survives. Taking into account the above, the learned trial court ought not to have granted the injunctions which have been passed by the impugned order. Consequently, the impugned order dated 11/12/2024, passed in Midge case number 288 of 2024, arising out of title suit number 47 of 2020, is set aside and quashed, It is observed that the quashing of the instant order shall not prejudice any of the parties in the reference proceedings. With above the instant proceedings.
Different. Sorry, I thought first appeal means after a long time it will.
First appeal will give you a
He
chance.
gave me good assistance yesterday night. I found nothing is there.
Item 6.
What happened?
My instruction is that, the inquiry officer has completed the inquiry and submitted it to the disciplinary authority. Now, submitted it to the disciplinary authority. Now, in the meantime, the disciplinary authority has changed. He has been transferred to some other place. New disciplinary authority has come. He is yet to take a call. She wants, 10 days time. She can, pass.
Ensure, na?
Sorry. I already communicated that. I communicated that.
Is the matter again of ensure you are happy.
Final penalty.
Again on 15th of May 2025 for
Fine.
taking into account that the disciplinary authority is yet to take action pursuant to the inquiry.
7.
Oh, you want to file affidavit?
2 weeks of accommodation also to bring the IS. We have been granted the director on the last order also. One last opportunity may be given. We must stand on the order.
Isn't this the same issue in the other one?
Madam,
There's another one, a petition filed by Mr. Ken Chaudhary.
Yes, madam, that was related to the issue of the framing of the High Court rule service conditions, which was not acceded to by the government. Now, of course, if that had been acceded to, this grievance would have been taken care of. But that has been rejected, and 2 rounds of litigation are ongoing on this. This issue is only related to 2 particular years, 2003 to 2005. 2003 to 2005. Prior to 2003, parity was maintained. In fact, they were at a higher position. Thereafter, there was a recommendation in 2002 by the Honorable Chief Justice at that time for assigning a fresh pay scale, which was substantially higher. That was rejected. Thereafter, my lord, that
Now they are getting as per the 7 pay.
my lord, not as per the 7 pay, my lord, there's a separate this thing going on. We are giving this extra pay because in 2005, 2012, the Shetty Commission recommendations were implemented with retrospective effect. Therefore, the staff of the lower judiciary, they got it from revised from 2005 onwards. And thereafter, our revision,
Revised. You have not got your revise.
no, we missed one step in those particular, we missed one step in this particular 2003 to 2005,
So there's, your salary is lower.
much lower. Only 2 cadres, only 2 cadres, the admin officer judicial and the court master. Others are again above the par with their respective counterparts.
Why discrimination?
Opportunity I'm seeing.
I gave you last time, one time, na?
Yeah.
2 months back. Almost 1 month
One
back.
month back, Lordship.
Then
Lordship, 2 weeks time maybe.
budget is going on.
Yes, Lordship, the,
Budget is going on.
no, Lordship, not because of the budget. But
Then what?
Yes, Lordship, I was not, the 2 weeks time maybe granted, Lordship,
Last time,
last time, Lordship.
they decide on the basis of the metal.
Lordship.
It's so dear the learning council. You think that time has been already granted to the finance department. 16 for filing the application. However,
Item 8.
ask for. Yes, what is this? The petition is so small.
No, I have received the instructions. in this matter.
I give direction to what is for renewal. What is your grievance?
But my grievance is that, my lord, in spite of the being senior, my lord, she was a senior in the category, my lord, but she was senior, by
So?
but that some junior was selected.
Senior from where?
They're from the same category, my lord. They are all are working as a peon, my lord.
You want to where? What post do you want?
My lord, LDA, my lord.
You want to go to LDA?
Now they were all working as peon, my lord.
Then?
Therefore, my lord, they are contacted and
Promotion done.
done, my lord. They had, what happened, my lord? It had promotional,
What is the name of the petition?
my lord, his name is, my lord,
Because Sandoval.
my lord. Dear Lord,
You are number 3.
my lord, dear Lord, yes, my lord. Additionally,
You want to become what? LDA?
LDA,
How many have you become an LDA? HSSLC. Double SLC cannot be an LDA. Any now? Sir.
Yes, now there is doubt as per the rule, but advertisement, it provides.
And what is this type of election done? You are doing it on merits?
No, yes, there is
This will be wrong.
exactly, that is what I was trying to say. If your lordship considers the marks, scored by the petitioner, 1.5 are the type of marks scored by the petitioner in written. And oral, 2.5, something like that. That is one aspect. But if your lordship considers the
No, you have to.
criteria, yes,
minimum.
if your lordship considers the criteria, which is that is seniority cum merit, then there is something wrong here. Because they did not follow
Appointment done.
minimum.
Appointment.
I am representing. If your lordships kindly take the instructions that they have also, I have specifically asked them that what have you done?
You should have a benchmark.
Yes, they said that they did not follow any benchmark, minimum merit.
Merit they should have.
Yes, my lord. That's correct.
To interfere with this.
Second last page, if your lordships
Who have
kindly.
been appointed. Only one line is required, that you should have a benchmark of 40 marks. And thereupon anybody senior. That should give them the 50 marks. What 60? 60 you will be.
But even for a moment, we assume that 40% is the benchmark, not 50%. Then also the possibility of petitioner is extremely remote. Going by the score, he marks his score. Secure. They had put individual question. Annexure 3A, the elongated page, if your lordships kindly take up, it has got the compilation of all the three interviewers. Oral test, 647.
Obviously, you cannot consider with them because of the fact that you see this person is an HSSLC. You are going to give it to 4, 6 and 7 who are BA. These are
Yes.
graduates.
The problem is
Are these
the
not the people who have been given 4, 6 and 7?
87 rules. 87 rules. That is rule 4C. It provides by selection on the basis of seniority cum merit from among grade 4 staff of the Chief Judicial Magistrate establishment ministerial concern who have passed HSLC or equivalent examination have rendered 7 years of service. That is the, as per the rule, the requirement is HSLC.
To
87.
LDA.
LD. The 87 rule.
But this goes against the ministerial rules. The state government. They have now amended it to make it.
Exactly. I think the new rule which will come, that will cover up all these aspects. What's the last for the security company that benchmark should have been there?
Where is the appointment orders?
The rate petition might be fine. Is 13 minutes, 18 minutes. Next 13. Three of them. Yeah. Email. Page 18. Single order.
Any reservation?
Yes, madam. One. LDA was reserved for STP and
The
office.
petitioner LD, STP? No, STP.
No, but it is there.
You're not STP.
Internal ST. One is a ST.
Please,
ST.
then, so Pangi,
One to Pangi is your also.
what is the age of the petitioner?
Right, date of birth.
No, in promotion, there is no age, na?
Page 40. Just 19. February.
Version 44. Point four, and given, wait, has he been appointed? Yes.
Yes, sir.
Oh, he of the same rank. Seniority. Same date of appointment.
In the, yes, 16/8/2013. Date of birth is earlier.
Huh?
Date of birth is earlier, मतलब. Certainly he will be senior.
So date of birth, you got seniority, otherwise no.
Otherwise, with Sanjeev Hajiga, on the joining, it's same. Date of joining with Sanjeev Hajiga is same. But from the date of birth, the between is senior.
Lordship can do one thing, subject to what Lordship says. They have done the merit assessment. But what they have done is that they have followed a wrong criteria. Lordship can direct the selection committee to follow a correct criteria. Yes, no, that has to, yes. Yes,
Order with a pass from.
in the morning method. In that even, another exercise for everything would not be required. Because if the assessment, because ACR marks will be same. Because there is a notification which provides for how much mark in good or how much mark
But
in
you
average.
have not fixed the benchmark. Problem arises there. Fix the benchmark today, you are changing the rules of the game. Indeed. There the problem arises. That is why in the earlier matter, so that was the biggest problem.
I understand that.
Now the benchmark you
I
can't.
understand.
Yes,
Yes, sir.
well, so below after the question. Is now scaled on the upper the 1, 2, 3, 4.
6, 7, and
And for couple it goes on top. He and puts the sport in grief by the non-selection of the petition to the post of LDA. Spite of the fact that now, tell me one thing, you applied for which post?
copies, my lord.
Huh?
Copies.
No, you did not. Be a prayer. LDA junior administrative assistant.
Yes.
Didn't apply for copies.
Second post of copies, one second post of LDA.
Huh?
There is 3 post mallet, 1 LDA with STP and 2 second post of copies mallet. They had considered mallet. They did not.
Which post did you apply for? Okay. LDA. System. Right. Comes with the criteria laid down by the Assam.
Assam Chief Judicial Magistrates.
There's no chief judicial magistrate.
Written in the that in order, page 18.
There's a chief judicial.
Yes, Assam Chief Judicial Magistrate Establishment Ministerial Service Rules 1987.
Same rules.
One is district judge, one is chief judicial.
Most of the districts. In terms with rule 6.5C.
Rule 4C, my lord.
4C.
Yes.
Criteria of seniority from merit. Even from before, Steve. Getting was appointed as a given in the in the year 2013. I did not dated 14/8/2013 and he published from 16/2013. Is the claim of the petitioner that the petitioner have been discharging his duties in accordance with sincerity and dedication and to the utmost satisfaction of the higher authorities. Seven nine 2020. Seven nine 2024. Pursuant to a resolution adopted by the selection board. The Chief Judicial Magistrate, Sagar, the chairman of the select, is asking various persons, including the petitioner and the respondent, 6, 7, and 8, appear in an interview to be held on 23/9 for open to one vacant post of LDA, STP, and 2 vacant posts of copyist. Like at UR. From the very notice, it would be seen as to that the notice would be seen that the criteria for the interview was set out. That is, ACR, draft of application, notes, etc. And the viva voce would be taken into consideration for the purpose of selection. During the course of the hearing, Mr. Ichkedas, the learned counsel appearing on behalf of the High Court, has placed before this court certain instructions along with the material records in the state records. So produced. The minutes of the meeting, the selection board held on 22/8/2024 was also placed before this court. A perusal of the said minutes of the meeting dated 22/8/2024 would show that the basis on which selection would be conducted, the procedure and the basis on which the selection would be conducted have been duly mentioned. However, surprises the court that although in terms of clause 4, rule 4C,
6/4
6/4,
6/4
6/4C,
6/4.
although in terms with rule 6/4C, the rules of 1987, the criteria to promotion to the post of LDA was seniority cum merit. But the minutes of the selection proceedings, the minute of the selection board held on 22/8/2024 did not conceive of fixing any benchmark to evaluate the minimum requisite merit and suitability of the candidate amongst the eligible candidate persons. It is further seen from the materials which have been placed before the court by Mr. H.K. Das that each of the 10 candidates who were taken into consideration were judged purely on merit. And this very aspect of the matter would be apparent from the instructions so placed it is on the basis of the said procedure so adopted. The impugn order was passed on 19/10/2024, whereby the respondent number 6, 7, and 8 were promoted to the post of the LDA, Judicial Assistant. Post of Office and LDA. The instructions which have been placed by Mr. H.K. Das is kept on record and marked with the letter X collectively. I've heard the learned counsels appearing on behalf of the parties in this regard. And I have also taken note of Rule 64C of the rules of 1987, which specifically mandate that the criteria for promotion is seniority cum merit. Taking into account the above proposition of law, it will be seen that the petitioner, that it will be seen that the selection committee, that is the respondent number 4 and 5, have applied the wrong yardstick and had in fact assessed the petitioner vis-a-vis the respondent number 6, 7, and 8, along with other candidates, on the basis of merit cum seniority and not on seniority cum merit. Consequently, as the above promotion so made is in contrary to Rule 64C of the rules of 1987, this court is of the opinion that the impugned order dated 19/3/2000, 19/3?
Yes. 1910.
19/10/2024 is required to be interfered with. Accordingly, the incident with petition stands disposed of with the following observations and directions. The order dated 19/10/2024 issued by the Office of the Chief Judicial Magistrate of Switzerland, whereby the respondent number 6, 7, and 8 were promoted to the post of copyist as well as LDA, are set aside and quashed. The respondents, in view of the setting aside and quashing the order dated 19/10/2024, the respondents, more particularly the respondent number 4 and 5, are directed to forthwith take appropriate steps to fill up the vacancy by following the mandate of Rule 64C, that is, and more particularly the criteria that is seniority cum merit, and in the manner as have been already stated here in above.
Much obliged.
9.
Nearby reaching 2024.
Sorry, my lord.
No, we are reaching now nearby to 2024.
Yes, my lord. I also, my lord, I have also completed most of my homework. I hardly have 3, 4 pending. That's good, my lord. Please, sir.
Yes, what is the scale of pay?
Yes, my lord. Benefit of the Shetty Commission recommendation to registrars of, to registrar of the industrial tribunal, my lord. My lord, the registrar of industrial tribunal has not been given the benefit of the Shetty Commission recommendations. Though, my lord, the industrial tribunal's labor courts are brought under purview of the benefits to be given under the Shetty Commission. If my lord comes to page 7.
Yeah, they come within the purview of the Shetty Commission.
They come. If my lord comes to page 79. 79. This is a notification dated 30th of July 2012, my lord. It starts at page 77. Page 79, the third last paragraph, my lord, just after
LTC, HTC benefits. The aforesaid benefits. Aforesaid benefits shall equally be applicable to staff of corresponding grade and status working in various courts like MSCT, family courts, industrial tribunal, labor courts, courts of special judge, CBI, special judge Assam, judge designated court, etc. in Assam, which fall within the sweep of subordinate judiciary.
But this document is only for non-judicial stuff.
Yes,
We are concerned with.
registrar. Registrar is the chief administrative officer. He's a non.
Where is that? You are referring to page 79.
Page 79. Starts from page 77.
Which post? Registrar.
Registrar is equivalent to Registrar. He's the chief administrative officer. Page 79, if lordship comes to.
You are referring to chief administrative.
Chief administrative officer.
Yes, finance.
Why not? There is another, if my lord may permit, my lord. There's the Honorable Committee of Judges, my lord, had also deliberated on this matter. If my lord comes to page 84, my lord. Starts at page 82. The resolution adopted is at page 84. Resolution number 5, my lord. It appears that the government of Assam in its notification dated 30th July 2012, which lordship has read, has mentioned that benefits given by the said notification pursuant to the directions issued by the apex court shall equally be applicable to staff of corresponding grade and status working in various courts like labor court, industrial tribunals, etc., which fall within the sweep of the term subordinate judiciary. Registrars of industrial tribunals and the labor courts in Assam are paid salary in the pay band of rupees 12,000 to 40,000 per month with grade pay of 5,400. Those registradars in the court of district judges, which is of the corresponding grade and status of registrars of labor courts and industrial tribunals.
First of all, what is the value of this?
It's a recommendation.
Let us not go by recommendation. Let us ask why the finance is making us step motherly. Why? Why do you don't give importance to industrial tribunal and labor courts? Yes, is the most pathetic of the court premises.
Admittedly, there is no recommendation of the city commission. The views of the finance department were okay. That lordship will find that my lord 103, page number 103. The petitioner had made a representation, my lord, before the registry.
Then 103 is what? Finance.
Yes.
There being no recommendation of the city commission regarding register of labor court and industrial tribunal, Honorable High Court recommendation for which solicitor to pay in the state pay scale as per ROP. As such, there appears to be no justification allowing. So what is the basis on which you are putting the registrar's rank?
Here we have not found any affidavit for that. I apologize for that. Some other concerns who are handling the matter today, I'm afraid it was it. Please to allow us to find an affidavit, my lord.
Because the question is, you have to equate somewhere. You are saying that you are paying as per ROP. You are paying ROP on what basis?
Post of register, my lord, it says, my lord, the register of labor court, the register draw pay in the state pay scale as per ROP.
ROP is going to which post?
That's what, my lord. ROP is there.
You cannot say that for ROP. This is the issue in the other matter where I am taking up the other one where Mr. A. Sulia has sought for a final adjournment. There he is asking the same thing. Whether it is there or not, whatever may be, it is the labor court also a court.
Labor court is also a court, but
And it is also an industrial tribunal is also a court. Maybe these are made under the purview of the Act.
under the
Industrial
IDA,
Tribunal Act.
IDA.
But they come within the ambit of the support of the judiciary under 235.
Then
So therefore, obviously, we cannot do anything about the pay. The pay has to be done by you, but you have to give the pay which is equivalent. Why you are saying that the labor court is different from the district judiciary.
So it has not been said as such. We say, my lord, this note appears to, my lord, send out a message that, my lord, in the ROP, my lord, the cadre of register is to be found. And then, my lord, specific cases are earmarked for, my lord, the post of.
ROP is against cadre of register. How is it fall under which case? For whom?
It is what, my lord,
Because the registers are mostly for
support, but
there
here,
any other department where you have registered? Then I,
But
there any other department where you have registered?
I don't think so, my lord, but most probably the state commission.
scale of pay, the register is drawing a scale of pay, my lord, which is to be found in the ROP. Now, the expert body is the state commission.
It will be found in the ROP provided it is there in the state secretariat.
So therefore, the register draw pay in the state pay scale as per ROP.
Understood, where? In which post?
Therefore, my lord, we need to
Doesn't
find,
come up with like
we,
this.
we need to find, so my lord, there are two aspects of the matter. We will find an affidavit, but primarily what I am submitting is that, my lord, admittedly, there is no recommendation from the SETI commission.
Is the SETI commission tomorrow, just for example, tomorrow it comes up with the NDPS Act is modified and says that, okay, we will have to have a special court for NDPS.
So
Then
therefore,
in that regard, are you saying that, oh, SETI commission not there? So do we pay them, what do you give it to grade 4?
issue here is, my lord. with
You
regard
cannot,
to-
these are all having the trappings of a court.
So, my lord, issue here is with regard to pay parity. He is seeking a pay parity with that of his counterpart holding the post of sales starter. That is plain and simple. Now, my lord, whether this aspect of the matter is supposed to be determined by the expert body, that is the pay commission. Therefore, finance department said, my lord, that it should be, my lord, placed before the next pay commission, which is the expert body. And to that extent, Lord, it is ever, my lord, that 2019-18 SCC decision, Bihar Research Cadre Committee, paragraph 92.2. So therefore, my lord, is how the pay parity is to be drawn, mode of appointment, equipment, qualification, nature of business, all these things will assume significance here. Simply saying, my lord, that I am holding the post of registrar, my lord, I am the administrative head of that particular court establishment. A person holding the post of registrar is also the administrative head of that court. So therefore, we have to have a same pay scale. That will not do, my lord. There are various parameters. So let me find an affidavit, my lord. It's not that he is out of pay, he is getting his pay, he is taking more. Kindly accommodate me for 3 weeks, my lord, I will come up with an affidavit. That way.
Star go to the council if you want. Taken note of that notice was issued in this case on P1/2025 and almost 4 months have passed, more than passed, but no affidavit has been filed. Subsidiary above, this is the matter on 29th of May 2025, a final opportunity is given to bring on record their stand by filing the affidavit on or before 21st of May 2025.
21st of May.
21st May, you file your affidavit. The petitioner, if so advised, will be at liberty to file the reply.
Deep your time. I'm okay.
Yes, any matter? What day we getting? What's that? Which day we getting in?
On stipulating matter, item,
Why is it before me?
item 17. Your lawsuit wanted to dispose of this matter.
For me. Hey, day we getting? Yes, what is this day we getting? Who has filed the stay we getting?
Well, okay, respondent number lawsuit, by seniority 6.
Who is your senior?
BD does has been engaged in this case.
Huh?
Senior counsel, BD does he has
what?
been engaged in this case.
So what? Senior counsel, Mr. Counsel, I don't grant adjournment for senior counsel. Don't mention names of senior. You say that you have a difficulty, I'll have considered.
Yes, left.
Yes, what do you want? Feel the next step, no further steps be taken, respond to fill the post in question. What is this? Challenge the illegal and arbitrary action of any driver under the Ministry, Talk Salmara Mankata.
Interim order. This interim order was passed on 11/12/2024.
Huh?
11/12/2024. And the appointment order also has already been issued prior to that, is 17. 9/12/2024. How to join because of the interim.
What has happened after that? Oh, I've extended it.
Yes,
We'll continue till then. Hello. There's a selection committee minutes.
That is,
Yes, government, what you are saying, is it the High Court or where? What have you, whom have you appointed?
Their contention is that 4 marks has been given in the Viva Voce. Their contention is that, Viva Voce, 4 marks has been given. But the selection committee, after considering the interview,
Who is
granted
the
the mark.
respondent number 6?
Respondent number 6.
but I am
Asked that the driving skill is all right, but the post of driver, but it to have something more apart from being driving skill. In that way, we have filed the affidavit. And we say that our contention is that there is nothing wrong in the selection process. How much mark interviewer will give to a candidate, but that cannot be decided by the candidate. It's for the interview
You have given 55 out of how much? 100?
out of 60 lots.
60. Then? No. Interestingly, wait. Mr. Das, kindly come to page 29.
29 years, my lord.
Okay,
Yes.
out of 160 marks.
No, my lord, there is some clarification. I'll just facing my lord.
Yes, others may go.
20 marks.
Page 29.
Yes, my lord, that I have seen, my lord. I'm just, egg second. Para 8 of the affidavit, my lord, will kindly come. Para 8.
Now, how much was it for?
My
This
lord, total
55
mark,
out of 60.
my lord, actually for driving skill, total 100 marks for driving skill. So the concerned MVI who conducted the test, he bifurcated into 2 parts. 70 marks for driving skill and 30 marks for traffic signal. But the advertisement doesn't say about this traffic signal thing, you know. Advertisement only says that you assess the driving skill, whatever may be. Then 60 marks for Viva Pose, 20 marks each of the interviewer. So
So is there any bias?
Yes, Lordship.
Is there any bias?
Yes, Lordship.
What is the allegation of bias? Bias against whom? Bias against whom?
Against the petitioner. Lordship, actually in the advertisement, there is no allotment of marks, Lordship.
Forget
I
about
have
that.
a challenge
They
there.
can have it on their own. I'm not saying bias against whom. You must allege bias that somebody has been given more marks, must be for some good reason. What's the reason?
Lordship,
The face of this particular petition, respondent number 6 was better looking. What is the reason?
Lordship, in the Viva voice, Lordship, 60 marks have been.
You got also 40 marks or 25. Another one, number 1 has got 43 marks. Do you drive a vehicle? Do you drive a vehicle?
Yes.
Okay. There's a difference. A person may very well may not know many other aspects. To write, he may not know, but he may be an excellent driver. Isn't it? He may know many other aspects. But why have you driving skills? Driving skills should be more, don't you think, in a driver?
true that driving skill has a role to play, but when it comes to a driver of a jet, I have
445.
fine.
Okay, we'll hear
Some
when.
other day. Can we do motion?
Is the matter next week?
Yes, thank you.
Not any. I'll stay. The stay vacating on. Stay vacating is alive, na?
Yes.
It's the matter on. Okay. First in the stay vacating column.
Fine.
In time order passing.